Yep. Thank you. I'd like to call a special meeting in Narragansett Planning Board to order. What's the date today? April 26th,
28,
two-
no?
2023. This is a continuation. Oh, first of all, Mr. Friday? Here. Mr. Brady? Here. Dr. O'Neill?
Yep.
Mr. Fleming, I'm here. Mr. Brunetto is absent with cause. We have one item on the agenda. It's a continuation, the master plan review, land development, comprehensive permit, Old Boston Neck Road LLC, 20 units, plat N-B, lot 30A, Old Boston Neck Road. We left off last meeting with a presentation by the applicant. I believe the applicant's attorney has additional expert witnesses to call. Is that true, Mr. Doherty? Can you step up there so everybody can hear?
Yes.
Thank you.
Patrick Doherty for the applicant, Old Boston Neck Road LLC. Mr. Chairman, yes, we have Paul Bannon, a traffic expert, here to testify tonight. We also have a corrected pro forma to provide to you. And I did, the town was provided, and I provided a copy to council as well, an updated letter of eligibility from Rhode Island Housing dated April 24th. It was based on corrections to the pro forma.
Yep.
So that is, that's in the file. I'll provide a copy of that to the board as well. I don't know if you've received
We received, it's in our, I think we
the
got,
April 24th letter
yeah,
from Rhode Island Housing.
I believe so. Let me just double check.
Yes, that's the one.
Yep. We have it, Mr. Doherty. Thank you. We don't have the pro forma, obviously. We just have the letter.
I'll provide one to the council as well.
Okay.
Going to waste for nothing. All right. A couple of issues, Mr. Chairman, and I'm sure council is going to discuss them with you as well. It was brought to our attention by the town when we were dealing with engineering that there was it was an incorrect meets and bounds description in our deed. The deed that was of record up until now cited in excess of 12 acres that encompassed the parcel B, which is the lot that is subject to, or lot 30 rather, that we are here before you this evening. However, the deed gave way more land than than the grantor was able to grant to us because he included the previously subdivided parcel that included the entirety of the 12 acres prior to the subdivision. The corrective deed, which I provided a copy to your council, it's not signed. We overnighted it down today. Both the trustees have already acknowledged that they will sign, but it references the final subdivision plan that is recorded, was accepted and recorded in the town of Narragansett. It's dated August 3rd of 2015. It was finalized and authorized per vote of the planning board on August 20th, 2019. And it's recorded in volume 13, page 1 of 1. And this is a town record that shows not only the entirety of the lot, it was the subdivided parcel B, which is going to be in our corrected deed, and it also shows the water line easement coming in from Boston Neck Road across the what was formerly the Seaview Railroad right-of-way, which is now part of Lot 47, which I believe is a Hannah Robinson LLC property. And I provided a chain of all the deeds from the original easement back in 1977, if I, hang on a second, please. The original easement for the installation and maintenance of the water line is at Book 101, page 549, and it was granted 16th day of June in 1977, provided an entire chain of title of all of the deeds leading up to the present one. The easement is intact and still alive, and it's on recorded plans in the town already. So, approved by this board as well in the subdivisions that have occurred prior. So we do have a couple of issues I'd like to present to.
Let me just get Mr. Marcellus.
Just for the record,
Yeah.
we're
am I talking? This one? Okay. So I was just provided with this tonight, and it was obviously just noticed by the engineering department today, I believe it was. I haven't had a chance to look over the title work for the easement. I will. I've noted to Mr. Doherty that the deed is unsigned and it's unrecorded, and that he proceeds at his own risk because the legal description encompassed greater amount. There's an argument to move forward. If I wouldn't move forward, but this board, it's my opinion that the board wouldn't have the ability to, basically deny this as the application being incomplete or anything like that. But there's clearly a defect in title that's not cured as of the time of the hearing.
And I think the defect in title, if I may, is that more land, including the actual lot in the substantive land within the deeded description, is included in that deed. A grantor can only convey title to what they own. They clearly didn't own the other parcel that is comprising the excess acreage that goes up to 12 acres, but it certainly did encompass the 6 acres that are before you here this evening. So we do intend to proceed. I'm going to provide you.
Well, let me just ask Mr. Marcel, so we're going to make a decision tonight. Are we able to make a decision if that's still up in the air?
I believe you would be able to make a decision. It's clearly appealable. Again, I wouldn't move forward, but the fact that, and again, this is what I do, the fact that there was more land granted in the original deed certainly would allow the applicant to move forward. It's something that, would probably be easily cured with a 30-day continuance, but the applicant doesn't wish to do that and wishes to move forward today. And given that, and given how the deed is phrased, it's my opinion they can move forward. It's clearly an issue, though.
But when you say you wouldn't move forward, if you were the applicant?
If I was the applicant.
Not the board?
No, the board can certainly
Okay.
decide on the merits.
So this is the applicant's call and at his risk?
It is. Again, it is.
Okay.
So just so you understand what we have been talking about here, I provided copies to my attorney, my opposing attorney, Mr. Perry, and I'd like to provide copies of the documents of which we just spoke that include the corrective deed that we expect to have within our possession and recorded, within the next few days, in addition to the original easement and also the original trustee's deed, which includes the description that conveyed in 12.51 acres. So the land that is comprising this development is included within that 12 acres. Obviously, we can't claim that we were given someone else's property. We can only claim that we were given what we have title to. So I'll provide copies.
Go ahead, Joe.
So you want this as evidence?
Yes.
Joe has a question.
Can you give me an order?
Let him do his work here.
Right-hand corner, left-hand corner, doesn't matter?
Just get the date on it and the number that follows up from last time, whatever the last one was. Oh, we didn't have any.
Trustee's deed.
Thank you. Okay. Yeah, go ahead, Doc.
Yeah, Mr. Nardi? Yeah, I must be a little thin here in terms of my hearing or understanding. So we were considering total acreage of the proposal was 6.1 acres.
That's correct.
That's changed now.
No, it has not changed.
It's not changed.
No, it has not changed. The issue is that the deed that was granting the property from the prior owner included a description and a number of acres that was erroneous. But that description and the acreage included, without question, the 6+ acres that are the subject of this application before the board. So we've acted to get a corrective deed, which is on its way via overnight express to the trustees of the Penta Trust, Mr. and Mrs. Penta. They have already indicated their willingness to sign this. We expect to have that returned and recorded within the week. So there is a grant, but the grant gave more than they could legally give. However, they did give us sold the property, the 6+ acres that are the subject of this application.
So at some point, Mr. Marcel, we'd be looking for some specific description that we would go into the decision.
Should you approve this? And
Either way, well,
if- I mean, wait,
either
either way, it would be a condition of approval, would be a corrective deed.
Okay. Yeah, Mr. Perry?
Edward Perry on behalf of two abutters. Just for the record, I'd just like to object to the introduction of this exhibit as a full exhibit. It's a draft, unrecorded document that hasn't been authenticated. I'd just like to object to that for the record.
Okay.
And that's where we're putting it in as an unrecorded, unsigned deed that we're representing is the corrective deed sent out. Just that, that's it.
Well, I hope all this gets cleaned up in the next week. Go ahead, Mr. Doherty.
Thank you. Mr. Chairman, I'd like to call Paul Bannon to the stand, please. Mr. Chairman, Paul Bannon is going to be testifying as an engineer, traffic engineer, and expert in that area. And I know he's appeared before this board. He's appeared before just about every board in the state of Rhode Island, and I'd like him recognized as an expert in that subject matter.
Yeah, can I have a,
Yep. Recognize, so moved. As an expert.
do I have a second? Second. Motion by Dr. Neal, second by Mr. Brady. All those in favor? Aye. Go ahead, Mr. Bennett. Go ahead, Mr. Doherty.
And Mr. Chairman, for sake of brevity, I know there's a lot of comments that are going to be coming on here, and probably people didn't, I don't see enough people bringing their coffee, but in the interest of brevity, I'd like to have Mr. Bannon provide a narrative of his report and go through it rather than question for question. It'll be a lot simpler, easier, and more straightforward for the board.
No, we want him to provide that, then the board can ask questions.
Oh, no, I'm talking about me. Do you want me to ask him questions?
Oh, no.
No. All right.
Appreciate the brevity. Go ahead.
I would never try to restrict your question.
Go ahead.
For the record,
Oh, you need to be sworn.
I do. For the record, my name is Paul Bannon, B-A-N-N-O-N. I'm an associate with Beta Group in Lincoln, Rhode Island. Our firm was retained to complete a traffic assessment for this residential development. As part of that effort, we conducted a review of the proposed site plan with the site engineer relative to siting of the driveway and access to make sure that safe and adequate access can be provided. We conducted site visits various times of the day, days of the week, to observe traffic operations. We also collected traffic data, including automatic traffic recorder, 24-hour data on the roadway and also at the intersection with Route 1A. We inventoried the project area for land use to see, what is located along the road and, the type of traffic that that generates. We obtained, we requested accident data from the local police department in an effort to review any crashes and see if there are any incidents of severity or trends of crashes along the road. And then we developed a trip generation estimate using ITE methods to estimate the volume of traffic that would be generated by this type of residential development. As was probably previously testified, the project is located along the westerly side of Old Boston Neck, approximately 900 feet south of the Route 1A intersection. The roadway is rural residential in nature, with homes off of the roadway directly and off of subdivisions on the road. The roadway itself is approximately, it's 22 feet wide, delineated by a double yellow center line. The speed is posted at 25 miles per hour. Is part of the data collection program. The traffic data found that the roadway services approximately 550 vehicles over the course of a day, which would be, typical of what you'd see for the number of homes in that area, like 50 to 60 homes along that segment of road. During the peak hours, you have between 7 and 8, roughly 55 vehicles per hour in the morning, and 60 in the afternoon. Looking at the count data, and where the road is and what it services, you can tell that there is cut-through related traffic, probably related traffic between southbound 1A and south to South Ferry Road, probably associated with the Bay Campus and/or the businesses that are located to the south and east of South Ferry. The new buildings will be built along a new subdivision road that will provide access to the property. The 20 units of residential buildings within the neighborhood would generate roughly, during the morning peak hour, 10 trips, and in the afternoon, 12 trips. As you can see, this is a low-volume generator. We assigned that traffic onto the local streets. We looked at what we said, the main study intersection with Route 1A. That intersection presently operates at a good level of service, C or better, and that will continue with that low volume of traffic associated with this use. Relative to safety, we requested the information from the police department. There were no accident records for the period we looked at, which was 17, 18, 19, because we didn't include the COVID conditions in our studies right now. And we usually do the full 3-year period. So we didn't collect information for 2022. Through correspondence, we understand that there may have been a couple accidents in the area. We'd be glad to do a supplemental request from the department and review to determine if there are any, what the causes were and if there are any issues that require mitigation. Okay. With that, we feel that adequate and safe access can be provided, as with the design proposed, along a low-volume residential street. I'll be able to answer any questions.
And when did you take all the readings? What time of year?
Last year, August, September.
In September?
Yeah.
So can you explain what people in your field do to adjust for, obviously, the summer months in
Well,
Narragansett?
the Department of Transportation has seasonal adjustment factors for their arterials. And, there's a balance, especially in this area, relative to summer traffic and school-related traffic. But we reviewed that information and feel our numbers were consistent with average or higher than average conditions.
Do you know if the state develops that based on specific areas of Rhode Island, or is it statewide?
They have count stations statewide that they review. They're required to obtain that data by the Federal Highway Department of HWA, and they develop on statistics for those roadways, whether they're urban, rural, collectors, arterials.
But not specific to Narragansett or Jamestown or Charlestown?
Yeah, they have recreational factors for Quinnick Island and Newport, so they They're
Okay.
around the state and they average them.
So you apply those factors to whatever data you collected, and you're still concluding that even at the peak times, there wouldn't be a,
Yes,
An
it's a low-volume roadway, limited. Most of the traffic that, does exit to the north turns right, and that's associated with, the cut-through traffic.
okay. Joe?
Yeah. You said September weekends, first day of September?
We did a full, Thursday through, full week of counts, Thursday through Wednesday. On the
What
road.
week? What week? The last week of September is totally different than the first week.
Yes, the week of the 19th through the 22nd.
Yeah, not to be critical, but you should be doing it in July and August, you know that, right?
If I
Yeah, we
don't
know
have-
in December and January, it's very quiet. Yeah.
Well, if I don't have a contract,
Okay.
I can't wait a year to do that, and that's why we look at the
You
seasonal
don't need
information.
my sarcasm. Yep.
Anyone else?
So did you look at pedestrian safety along the road all, or consider that?
We looked at the roadway itself and what it is. It doesn't have any pedestrian accommodations. During our visits, we did see pedestrians or joggers using the road. But but the sight lines are available. It's a typical rural residential road that doesn't have sidewalks.
And so your numbers, 10 additional trips in the AM and 12 in the evening from 20 households?
Yes. That's an industry standard, well-documented rate.
Is that based on bedrooms? Is that how they do that, or?
No,
Or just a residence?
There's numerous land use codes in the manual that we use. There are numerous residential types of, whether it's single-family detached, single-family attached. They've condensed, because of the data, whether it's apartment, condominium townhouses, into multi-unit residential, because that's what the data shows.
Terry? Yep.
May I throw in a comment? Or actually ask Mr. Bannon to elaborate a little, because understanding traffic analysis can sometimes be confusing. You said it was 10 to 12 trips during the peak.
Correct.
The afternoon peak. Please explain that the peak is 1 hour out of the day, and that the peak is similar to a peak in a chart. So before the peak and after the peak, you also have traffic. I think the question is, how can 20 properties only generate 12 trips? So if you could
Understood.
elaborate a little.
What we do in our traffic studies, we look at, when we say peak hour, it would be the peak hour of traffic associated with that land use combined with the peak hour traffic on the adjacent roadways. So, yes, you may have 2 cars as a residence, but someone may leave at 6 in the morning. Someone may leave at 9 in the morning to go to work. Our peak hour falls between 7 and 8, so you have a certain, one house is that way, another house may be both people leave at 7:30 every morning. So that's the difference. Each house generates X amount of worst case condition. That's the number we look at. So you may have, 5 cars that leave at 6 in the morning, 5 cars that leave
Got
at 10.
it.
So
Thank you. Thanks, Mike. Mr. Brady, are you all done, Mr. Friday? Yes. Mr. Brady?
Yeah, thank you. How many cars per dwelling do you estimate?
that's a variable. I have no idea.
What's the national average?
I don't have that. It depends on bedrooms and the types
Well,
and
there's 2
where they
bedrooms.
are. They could be, you can be in an urban setting, in an apartment, there are, less than 1 car. It's
Yeah, in a rural setting. You stated that this was a rural setting, and that's confirmed by applicant. The majority of the surrounding neighborhoods is made up of single-family dwellings and large lots. There are a few very large lots with one or more dwellings, units, several vacant, and open space. And they gave a density of 0.3 dwellings per acre. So that's consistent. So, so in your calculations, you don't look at how many cars per unit.
No,
That has no relevance?
no. Because it's the number of units, and that's factored into,
So the number of units times the number of cars.
no, we don't, as I just explained, what we look at is we look at the peak hour of traffic associated with that land use. And that's the period that the
And
highest
those
amount.
are developed based on, you said was, I wrote it down here, I apologize, the chip generation manual?
Yes.
Published by the Institute of Transportation. Now, those are averages, right?
They're depending on, well, there's average rates, and then there's formulas that if they have enough in the data set.
But it's data taken from groups all over the United States and I believe Canada, correct?
Correct.
Is Rhode Island included in that?
No.
So Rhode Island's not
Not that I'm
included.
aware of.
Okay, so these are averages outside of Rhode Island.
But they're consistent with data I've collected over the last 30-plus years in Rhode Island on studies that I've done for subdivisions and residential.
So I did some research, and the national average is 2 cars for 2-bedroom units, 2 cars. Rhode Island is also 2 cars, and Narragansett is actually also 2 cars. So we have 20 units, so we have 40 cars, and so we have a potential, based on your own studies here, because you at peak, you look at traffic coming in and traffic going out, so we actually have 80 potential trips. And what you're saying is 10 trips in the morning.
Yes, I just explained that. Everybody doesn't leave.
I'm
at the
just
same-
asking questions.
And arrive at the same time.
Yeah, all right. All right. You stated that this is a rural road, and the applicant confirms that it's a rural setting. Yet, when you write an approach to your study, it's page 1 in your study, and again, your name isn't on this, so I don't know how much of this you have seen or not seen, but the initial assumption, which is to me the driving assumption in this, is that this is, and I quote, a proposed small-scale residential project. These are 20 units in an area that the applicant has stated has 0.3 units per acre. And that's not substantial?
That's not referencing the density of the development. It's referencing on a small scale the amount of traffic that would be associated with that size development, which is low.
Okay, my other question is, you used national data rather than local data. I mean, straight generation, you had, within a stone's throw, you have similar type of developments, 2-family units, Indian Trail, Park Avenue, there's half a dozen others going up Boston Neck Road. Why didn't we use any of those to give a better picture of exactly what was happening?
Because the IT trip generation manual is the industry standard accepted reference in developing trip for developments. Local communities require it, the State Department of Transportation requires it. Unless it's an oddball that is not in the manual or there's not enough data for that type of land use, yes, we do our data collection at a like or similar development, so we can use that as justification. But this is a standard lot of data for these types of developments, and this is what occurs.
You state in your study that future traffic, PM peak is an increase of 2 cars as future development. What is that based on?
I'm not sure what you're referencing.
Was had it tabbed someplace here. Becoming a victim of my own tabs.
We used a 1% base growth rate, if that's what you're referencing.
Okay. So what does that assume? 1% growth rate?
On adding traffic to the
Okay.
count information that we have, we usually look at population trends in the community, and
But doesn't this 20 units throw that 1% growth rate out the window?
it's community-wide. If the community is seeing a decrease in population or level, and we use 1%, we're conservative in adding traffic to the traffic stream.
So traffic can't develop in spot areas any different than it develops across the town?
No, it will look at if there are known specific developments that may affect traffic on that particular roadway, we'll include that in addition to the base traffic.
So you didn't account all the rural, all the vacant land there that could easily be developed into high-density
Now, if it's not planned or under construction, we wouldn't consider that.
So that growth is just hypothetical.
It's higher than what the average rate is, or has been for the last decade, based on census data.
Okay, you want it?
Okay, I'm done. Thank you very much.
Okay.
welcome.
Thank you, Mr. Bennett.
Mr. Bannon, I just have a couple of questions to ask you. Excuse me, someone down the wrong way. Mr. Bannon, based upon your expertise in the area of traffic, is it your opinion that there will be no significant?
Can you hear?
I'm sorry?
Can you people hear? Put your hand up if you can't hear, because we only have one mic, yeah, in the back, they can't hear. We only have one microphone up at the stand there, so put your hand up if we, we all drop our voice. Thank you.
Mr. Bannon, based upon your expertise in the area of traffic studies, is it your opinion that there will be no significant negative impacts on the safety of current or future residents of the community with regard to safe circulation of pedestrian, vehicular traffic as a result of the proposed project?
Based on the data we collected and the study that was completed, it was determined that safe and adequate access can be provided, and there will be no detrimental effect on public health, safety, and welfare.
And based upon the design of the proposed project, is it your opinion from a traffic perspective that the safety of current residents have been adequately addressed with the design of this project and the intensity of the use?
Based on our study, we did recognize that travel speeds are higher on the road than posted speed limit, i.e. being posted at 25. At 85th percentile, what we say the design speed of a road is up to 37, 38. I'm not aware any requests from the neighbors, residents along the road to the town to provide traffic calming measures. There are no traffic calming measures on the road. It is a wide open road, it's cleared beyond, so it's an inviting road to generate those speeds. So, we're willing to work with the community if there are any issues or that need to be addressed that we can include as part of this project to traffic calm the roadway. We'd be glad to assist in that effort.
Okay, thank you.
I have nothing further, Mr. Bannon.
Thank you,
You're
Mr.
welcome.
Bennett. Do you have another witness?
Actually, in light of the updated staff report, I'd like to call back Mr. Pimentel to address some of the statements made with regard to the affordable housing element.
Yeah, I just wanted to clarify.
Let me
Oh,
ask you a
sorry.
couple of questions.
Do you have to be, does he have to be re-sworn in? No.
Yeah, he's already there. Mr. Pimentel, have you had the opportunity to review the April 26, 2023 addendum to staff report?
I have.
And have you reviewed the provisions beginning on page 2 and carrying on to page 3 with respect to substantial progress and the town's meeting the state target of 10% affordable housing?
I have.
And do you agree with the statements that are made in the updated, the addendum to the staff report?
Well, I think it's the way you're applying the numbers. So,
Well, do you agree
Well,
based
well-
on the statements that have been made?
I can't disagree that maybe 259 units have been approved, that would be 25%. The difference, though, is you have to compare to what the community had back in 2004 and what has been accomplished since then. So this is based on information garnered from the town. So in 2004, based on your affordable housing plan, you had 204 units. That's what was detailed. And based on the current number that was garnered in 2022, you now have 276 units. So the difference is 72 units. So if you take the 72 units that have been achieved over the last 17, 18, 20-year span, it's really only a smaller percentage that's in the report. I think what the report is saying, what have we done in the last 20 years? But we got to show where we were and where we are now. So the reality is, if you take the increase, so there must have been a loss of units somewhere along the line. Otherwise, you would have had the addition of the 163 units plus the 204. You'd be in the 400-unit range. That would be quite significant. But the reality is it's a 72-unit difference. So when you subdivide the 72 by what's detailed here as being the 672 new residential units, it really comes down to 10%, not the 25% that's documented here. That's how I looked at it, because you're showing progress. This is where we are. This is where we are now. Otherwise, yeah, you could pick any 1 year, any 5 year, you could pick any increment and say, look what we accomplished. But the reality is we're trying to get to 10%. We're trying to get the number of units, not only attract units, but retain units. And that's always the problem. We get units, sometimes project aren't completed, sometimes they're approved, not constructed, sometimes we lose units. That's been the difficulty and the problem. So the reality is you're at approximately 3.86%. You were at 2.9%, and based on these numbers, you've only attracted you've added 72 units over the last 18 years.
Thank you.
Thank you.
Yeah, I'm gonna,
Before he sits down?
wait a minute, Mr. Pimentel. Joe?
Yeah, for the edification of everybody here, we keep talking about the 10% and why the affordable housing. And at least in my conversations with people in the town, they don't understand it. You know, who we're talking about. The fact that the state of Rhode Island is putting this burden on the towns, we need affordable housing. Everybody understands that for people who work. You know, the nurses, but we're in deep trouble over at the hospital. We don't have affordable housing. Could you speak slowly, though, right?
Sure.
Could you take 2 minutes to explain this 10% burden, because I know that's your field.
Yeah, I've always said I have a problem with imposing any just arbitrary number. I agree with all planners in that, because there are communities that need far in excess of 10%. There may be communities that need less, but the reality is we don't live within borders either. Somebody in Narragansett who may need an affordable unit may work outside the city and vice versa. My experience in the last several projects that I've done, the one we completed in Lincoln, we actually attracted almost the majority were in-town residents, because real estate values and everything is so expensive. So people were property rich but cash poor, and they couldn't maintain it, so they was time to leave the community that they had established long roots in. This development just was attracted and was absorbed by in-town residents. So there's a lot of that going on. But the reality is we shouldn't be defined by borders either, right? The state of Rhode Island needs affordability. Every city and town needs affordability. Every city and town has school teachers and police officers and firemen. You got police officers serving Jamestown that can't even live in Jamestown, so you can protect them, but you can't even live there. These kinds of issues. But you have to impose some kind of regulation, so we impose an arbitrary figure, 10%. But the reality is we could have imposed 6%, 7%. We're just having a tough time attracting affordable housing statewide. I said it before, the same handful of communities that comported with the regulations in 2004 are the only ones that comport now. There's a couple that have made incredible leeway. Town of North Kingstown is approaching 9%. Granted, they did a lot of transfer development rights to Post Road, so they kind of concentrated. You really want to also disperse throughout your community. It's been a difficult thing to do. So what do? Here's how I do it. I break it down into three type segments.
Quickly.
We either go very small. We add a unit. But what are we doing? We're adding 1/10%, so we move the needle 100%. Or we go mid-range, like what we're doing here. but the argument always is, but you're not really moving the needle. So at the end, you have to do really high-dense projects. But South County communities don't have the land resources to accommodate high-dense. We're doing one right now in East Providence. It's going to be 160 units. We have the infrastructure, we have the ability. It's going to be all affordable. South County counties don't have that kind of infrastructure. When you find a piece of property that can be densified, clearly we need to justify to this board at the prelim stage that this can be properly engineered and the infrastructure. But when you find a property that you can densify, you got to start densifying.
Thank you, sir.
Thank you.
Thank you.
I want to get going, but go ahead, quickly.
I've got some questions. You state in here that this site is suitable to build because property is literally almost entirely free of any developmental constraints. You talk about the fact that it's cleared of trees, et cetera, no buildings. That you give no consideration to soils, vegetation, water table, adjacent waters, seasonal streams, wetlands, and runoffs. Isn't that tangible, fundamental planning?
At the master plan stage, you take into consideration what you know to be on-site constraints. So if 1/3 of this property was constrained by wetlands, then I would have subtracted that out. Those other type of factors that may be discovered during the prelim stage when you start doing the engineering, yes, and that's what will affect density. But at the outset, it's impossible to know on a case-by-case basis what the true constraints of a property are until you get into the hard engineering. Otherwise, we could argue that most properties in Rhode Island are constrained from a high water table perspective and so forth, and we could argue that we should only develop in really select few areas of the state. This is why I say we need to get in there to find out what the real constraints of the property. But from a preliminary, just very conceptual stage, you base it on what you glean from the comprehensive plan. And, of course, what's provided by the engineers.
But in the very next page, you go on to cite exactly all of these things as restrictions to high-density development. And you talk about the fact that the combination of these developmental constraints, coupled with the community's desire to concentrate higher densities in limited areas capable of accommodating said densities, evidence the appropriateness of permitting a property. Isn't it accommodating said evidence appropriates of permitting property intensification? Isn't that a fundamental thing of seeking out areas for high density and identifying them as high density areas that have sewer, have limited runoff, have limited wastelands, have limited impacts, maybe have a better traffic flow or higher accommodations for these things? Isn't that fundamental planning?
That is fundamental planning. That's why, as a planner, from a very conceptual stage, I've got to rely on the comprehensive plan and the information that's been gleaned on a 20,000 aerial view look. Even in your 2004 affordable housing plan then and even now, it states that this property, I guess we're going to submit it into the record, right? You want to? This property, if you look on this map, had the potential for density bonus. What this did in the affordable housing plan is from a 20,000 view, is what are the areas that we already know outright, there's no way we can accommodate greater density or further development. And so it was trying on a very conceptual level to determine where should we start to look at for greater density. Then when you get in there, then you start doing the hard engineering to determine whether the density can be accommodated.
Yes, but
It's
you also
impossible
state,
otherwise.
You also state in here that you recognize that this is an R80 zone, which the community has used to identify areas of high sensitivity as far as environmental, wetlands, soils, runoff, et cetera, so forth and so on. That's at 80,000 feet, which is where you're flying.
And that's why I said last time when I testified too, when we impose zoning for two reasons. Either A, the way an area has already been historically developed. If an area has been historically developed for commercial purposes, we zone it commercially. And the other one is when we're unsure, especially when it comes to residential and areas that have spotted areas that you know is constrained, you impose a low-density residential designation because you're not sure you can't do it on a property-by-property basis until you get in there. There's a lot of area in northern Narragansett that is constrained, no question. Should remain R80. The question is, when you find pockets like this, could they potentially be developed for greater density purposes? This lot right now, from the 20,000 aerial view, doesn't have those constraints on it. Could we discover those later? Potentially. But from the aerial view, from the 20,000 view, no. And those pockets exist. Zoning is imposed on very arbitrary information because it's based on a broad-based perspective, not on, like I said, a specific property perspective.
If I may, we're going to have opportunities to ask all the expert witnesses questions. I'd like to get Mr. Doherty through his presentation so that we can move on. But I know that, but do you have one more? No, but we're going to have another opportunity to do this. Go ahead, Mr. Brady. You all set? Yep. He's all set.
Thank you, sir.
Again, I'd just like to remind the board, too, at a master plan level, this is conceptual. And as Mr. Pimentel stated, we're going to have to meet very strict, rigorous regulations in terms of wetlands, in terms of water table, in terms of soils, in terms of all that stuff. And if we can't satisfy the regulatory agencies in this board at preliminary and final, then we won't get this project. It won't get approved. This is just the initial step, and it would be ridiculous to suggest that a developer should spend those tens of thousands of dollars. I mean, they've already spent tens of thousands of dollars here, but to spend the amount of money to do the in-depth engineering studies and all the rest of it when they don't even have a conceptual plan approved. That's why the state and the General Assembly in its infinite wisdom made a 3-stage process for approvals. And you've had them here before you on just about every project that you've had, except for those that you've combined master and preliminary for. So we're not saying that these aren't concerns that have to be addressed. We can't increase the net runoff. We can't impinge on the wetlands. We can't not treat the waste on site. Those are must-be's in order for a project to proceed. But in order for the money to be put into that and the studies to be done and the evidence to be produced through that scientific study and testing, we need the preliminary approval. Otherwise, you're just rolling the dice on a wing and a prayer. No developer would do that, especially in light of the amount of money that it's going to take to develop this site. So we're very mindful of that. And this is project, even if it gets approved tonight, it doesn't mean that it's going to go forward. It means that it gets the opportunity to prove to you that we can meet all the standards and that we can satisfy all the regulatory agencies as well. But that's when preliminary and final approval comes in. Thank you. Now, I would just like to ensure that the the April 24th, 2023 letter update on the LOE, the letter of eligibility, is included in the packet as an exhibit. If not, I have copies of it. I'd like to make that part of the record.
It is included. And do you have an updated financial?
Yeah, I have one right here. That's right in my folder right now for you.
Why are we getting this now? Why didn't we get this sooner?
Because well, let me get on it.
Mr. Doherty, this was attached to our package we received today.
That's exactly the one. Thank you.
All right.
I had asked for this stuff to get into us earlier.
Sure. Well, the thing that I would like to point out first off is that the pro forma is not a basis on which you can accept or reject this application. This is just a requisite thing that shows that the project can be built and that it's feasible from the developer's perspective. But I do want you to understand, the numbers that are contained in here are going to change. It's without question. They changed since we did the initial one. The plans changed. But it's important to understand, a year ago, there was about a 17% profit on the expenses. The current one is closer to 13%. When Rhode Island Housing drops the sales price of the affordable because of increased interest rates, which I don't see anyone seeing those going down rather than up, the profits can also go down. And in addition to that, construction costs continue to climb. It gets harder to obtain construction financing. It's very likely that the profits on this particular project will go below 13%. And the important thing about this is there's builder's risk involved in every construction project going forward. And it's important to view this from the context of whether or not this project is feasible. And it can be built for the money that is being put in there and the prices that are being targeted for this. So it's very important to understand, when we get before you in another time, this thing will change. It's absolutely going to change. And Rhode Island Housing recognizes that as well. And they're the regulatory body that really has the say on the pro forma with respect to this. There's nothing contained in your regulations, and there's nothing contained in state law that allows you to say up or down on a project pro forma. And if your counsel can dispute that, I'd love to hear it.
No, we understand that, but it speaks to the density issue, which we have to address. It speaks to, as your experts say, the numbers don't work. So we got to see the numbers, because the comp permit rationale is I need more units because otherwise the numbers don't work. So we need to see the numbers.
Yeah, and that's really going to the letter of eligibility with Rhode Island Housing rather than this board, respectfully. I mean, I just don't see anything in your regulations that links that up, and I've been at other cities and towns before when that's...
I think it's a relevant point. I understand it's not a standard review. We can't make a judgment on it, but we can factor it into the conversation about density, because that's what people have an issue with. That's what this board has an issue with. We told you at the pre-app, too many units, not enough affordable. So density is still on the table as a big issue, right?
No, density's always on the
Right,
table. isn't
and
it?
this speaks to the numbers don't work. I've heard that so many times out of Mr. Pimentel and other people, if we don't get a density bonus. So we got to see this, so we see, I don't know if 13% is reasonable or not. I don't know. I did have a question about the site acquisition. There seems to be a discrepancy about the cost of the land
Well,
based on the deed.
well, the cost of the land is only part of the acquisition costs.
Well, can you explain that then?
Well, I don't have personal knowledge of that, but again, I think a lot of that is proprietary. I think the interest costs for the acquisition on the loans for purchasing the membership interests in the LLC, they all go and are getting wrapped into that. Do you want to speak to that?
So who produced
I have a
this?
member of the LLC, Mr. Santilli, here to speak
Who
to
produced this, Mr. Doherty?
that. This is Mr. Santilli.
Okay, so Mr. Santilli has to be sworn in.
I do. I do. Thomas Santilli, S-A-N-T-I-L-L-I.
So, Mr. Santilli, the site acquisition, it lists two headings, 200,000 and 640 for a total of 840.
Right.
How is that different from the price of the land that you
The
paid?
original acquisition was 720.
720.
We bought a partner out.
We bought
A
what?
partner out that was partners with us, okay? And carrying costs and cost of money. It's all part of the cost.
You bought out a partner.
Correct.
So,
I mean, the number's the number. That's the cost.
Mr. Marcel,
so
can you help me with that?
Yeah. So typically, an acquisition cost is the cost of the land, the cost of the closing attorney, title insurance, other items like that. That's the cost to acquire the property.
Okay.
And it's going to get higher.
Let him finish, will you? One at a time and let him
Sure.
finish.
No problem.
Whether there are investors that have to, are bought out or not bought out, really doesn't have anything to do with the acquisition of the property. In my experience, and again, I've probably done 20,000 closings, that is your acquisition costs. Other things, for instance, carrying costs, in this case, would be the interest keeping in mind that in this case, the seller is holding the note. So that would be, my opinion, there would be less acquisition costs because you wouldn't have to pay an appraiser, a lender, and all the other, I would call them bank costs that a normal developer would have when you purchase the property. You have additional acquisition costs. In this case, since the owner essentially held the paper, and you know, it's a 4-page mortgage, I can't believe Mr. Resnick charged more than $1,500 for the closing. So in my opinion, that would be the
The
acquisition cost.
the 720 plus the closing
Yeah, and
costs.
again, you don't have any additional bank fees, you don't have any additional bank appraisals, you know, those things can run $5,000, $10,000 sometimes. In this case, you wouldn't because it's seller financing.
I'd like to add to that.
Go ahead.
Okay, so I have a $500,000 note with the seller. I have $220,000 of my own money in there. I have a cost of money. Like, if I borrowed from a bank or borrowed from myself, there's still a cost of money. Correct?
Okay.
You don't put your money in the bank and get 0% interest. Not anymore.
All right.
Thank you.
So the original, just so we're clear, the original pro forma that this has been updated had the affordable units at 80% AMI, correct? And now it's been adjusted. I think it was 100% AMI, and now it's at 120. So that cost per unit that was 260,000 each something is now 320, according to this.
Well, yeah, but again, what you have to understand is the interest rates are going up, and there hasn't been a determination as what the financing costs are going to be and what would be an affordable price for a purchaser of the property. So this is all going to change. Again, it's going to change as time progresses. Interest rates go up, down. They're more than likely going up. So the value or the profit will go down as a result of the decrease in the purchase price. But again,
I'm sorry, why would it purchase because of this?
Because
of the 120% affordable?
yeah, and if the interest rates go up and the cost to borrow the money to get into one of these homes for a candidate that's accepted based upon income, if the cost goes up, the purchase price has to go down if the interest rate is raised. The amount of money to service the debt on that will necessarily draw the price down.
Like-
the market rates will be totally different.
They could go up.
They could, yeah.
They could go up substantially.
Or they could go down. You know, I just represented someone in a development in North Kingstown, and they, you know, it wasn't as big as this. It was, I believe, a 6-lot subdivision. And at the end of the day, when the interest rates were going up, we had to drop the prices down to sell these before the market got cold. And so the price went way down on what the pro formas were for the construction and the profit and everything based upon the interest rates going up. The price had to go down. So not only will the price go down for the affordables based upon a person's income and the target level that's you know, made to be the target purchaser of the low and moderate income housing, but the purchasers of the market rates too. The price could probably go down as well because of the cost of the interest.
That would be a first in Narragansett in the
Well,
last
it's
20 years.
Yeah, but it's going to happen.
Well, it
I mean,
might, but,
I don't
I
have
mean,
rose-colored glasses
If
on
I'm
right
hedging
now.
it either way, I'm hedging it's going
Yeah,
up.
one thing could happen across the pond over there, and all hell
Okay.
could break loose in the finance world. And people are, I mean, that's common knowledge. It's a scary time to be doing any kind of development anywhere right now.
Okay. Thank you. Does anybody else have any questions on the pro forma? I'm kind of, I would, before you say, Mr. Brady, Mr. Santilli, you probably should put your name on this and sign this for the record so we have that it's from somebody.
You just had testimony.
I know, but I would think it would be normal for a document to be signed. So you don't have to do it now. Just, we know you did it, but go ahead, Mr.
No,
Brady.
here you go. Do you want a signature? Here it is.
Thank you.
Santilli, how
I'm well.
So based on today, you're looking at basically $70,000 a unit profit at the end of this.
To carry?
At the end of the day, based on this pro forma, all right, if I'm looking at your total revenue, total expenses, what you net out, so it's $69,987 per unit,
Okay,
ballpark, yes?
yeah,
Okay, I just wanted to make sure my numbers were right. Thank you.
okay.
Thank you. Okay, Mr. Dougherty, we're going to go to the other attorney unless you have more.
No, that's fine.
Nope, we're all set. Mr. Parry?
Oh, and I just would like that record to reflect as well that I did provide to your council all of the deeds and the chain of title from the original easement up to the present prior to the meeting, and I'd like those included in the record.
Oh, and just for the record, there was something in here from Mr. Lombardo, is he not?
Yeah, Mr. Lombardo is out of state and he's unavailable, so we're going to just have the pro forma speak for it, or the fiscal impact analysis speak for itself.
Fiscal impact.
Yeah.
Okay, it's in the record, though. It's in our package. Okay, thank you. Mr. Perry?
Good evening, Mr. Chairman, members of the board. Again, my name is Edward Perry. I'd like to call to the board, two of our expert witnesses. I believe they're going to be presenting in a joint tag team fashion, so I'd like to proffer them separately, but at the same time as experts. They're both from Narragansett Engineering, based out of Portsmouth. The first expert we have is Neil Hingorani, and he is a land surveyor. And why don't you just give a brief background about yourself and if you've appeared
Yeah, if you
before.
can explain.
Actually, Mr. Chairman, we'll stipulate. I've used Mr. Hingorami as a land
Okay.
surveying expert in the course, so we'd stipulate.
We just want to hear from him, and thank you. Go ahead. Yeah, you need to be sworn in, sir.
I do. Sure. Neil Hingorani, Hingorany. And yes, Neil Hingorani, I'm a professional land surveyor, environmental scientist, principal of Narragansett Engineering. I've appeared before this board maybe half a dozen times in the past.
Yep.
If you need more, I'm certainly happy
Okay,
to elaborate.
and you need to be sworn in, sir.
I do. Joseph Malo, M-A-L-O, an engineering manager at Narragansett. I'm a PE since 2012. I've been doing engineering since 2008. I haven't presented in front of this board, but I've presented in front of several other boards throughout the state. I've been doing site civil design for Park Corporation, Fussin O'Neill, and then Donan Engineering, and then I've been with Narragansett for the last 7 or 8, somewhere around there, months.
But you're an engineer with the firm?
Yes, sir.
Yes, sir. Okay. Is anyone going to accept these two gentlemen?
Yep, so moved.
All those in favor? Aye. Okay, thanks. Go ahead, Mr. Perry.
Great. So my company was retained by abutters to this project. Abutters to
Yeah,
this
you need to
project.
get
Thank you.
closer to it.
By abutters to this project to review the plans and materials submitted for master plan review. We'd offer the following comments regarding the proposed development. We understand that full engineering details are not required at this time to be submitted for master plan. However, would bring a few items to the board's attention that relate to project feasibility and impacts to abutting properties. It's a dense development in an R80 zone, considering the density of units and lack of sewers and their restrictive soils. Obviously appreciate the need for LMI developments.
I don't hear you well either, so please speak slowly and clearly so we all can kind of.
Sure.
get
Appreciate the need
your
for
expertise.
LMI developments. However, the density on this project could lead to environmental issues as proposed. If the project cannot meet the OWTS or drainage requirements, it may not be able to support the proposed density. In particular, as has been discussed, there's a lack of flagged wetland edge. The consultants have mentioned it has since been filed. Certainly haven't seen any updates, but an updated delineation should be provided, and the plan should be updated. The freshwater wetlands regulations, including the coastal CRMC freshwater wetlands in the vicinity of the coast, changed in 2022. The site is in River Region 2, and based on these updated rules, it does require a 75-foot buffer, but it also requires a 20-foot construction setback. The plans do note a 75-foot setback has been provided, but I don't see the 20-foot required construction setback. That construction setback relates to principal structures, particularly units 10, 11, and 12. Would appear that they don't meet this, this setback. So this would require a variance from CRMC, and certainly I'm not coastal, but given the density of development and the environmental constraints may be hard to justify. We created a site map that displays these buffers and setbacks using GIS. I think it's also worth noting there was an isolated wetland in the northeast corner of site that appeared on previous delineations and files that we have. Thank you. Again, the applicant's consultant testified that he walked the site. That's no longer present. I think I would just offer that, you know, with these conflicts, it would obviously be prudent to have the delineation application from coastal to understand what these impacts are. They would be the arbiter in this case. In terms of soils, at least in my experience, class 4 on-site soils testing is often or typically performed at the master plan stage to demonstrate that the septic systems and the drainage is feasible for development, particularly when the soils are restrictive as they are here. Again, not only to ensure project feasibility, but certainly to protect the owner's interest. These soils are rainbow and stissing silt loam. I'm sure you are all aware. These have perched water tables, often in the 18 to 30 inch range. When dealing with a septic system, this is a restrictive feature. Both the soil category, which is the soil's capacity to infiltrate, and the water table depth are critical for system sizing, design, and feasibility. The information submitted as part of this application, in my opinion, doesn't adequately address the feasibility of these systems. The applicant's consultant testified that no soil evaluations were performed in the area of the sand filters, so the septic systems. They also noted that they used the NRCS soils maps, which definitely give you a 30,000-foot view of the project, but again, with these restrictive features, inches can make a huge difference. So if it's a...
Can you enunciate, please?
Sure. If it's an 18 to 24-inch water table, that would require variances from DEM. A 25-inch water table may give them the flexibility to design systems without variances. So those few inches can make a huge difference, which is why on-site soils testing is generally important. They did note that they used the 18 to 30-inch range based on the mapping. It appears, based on their calculations, they used a Category 7 soil calculation. Joe will get into that more, but that basically reflects the soil's capacity to infiltrate. So loosely, Category 1 is the best soil, high-capacity sand, whereas a Category 9 soil would be a very, dense, silty soil that doesn't accept stormwater or wastewater well. Research at OWTS and community development actually indicates that soil testing was performed on this site previously in 2015. That was done by a licensed Class 4 soil evaluator. From the ones I could see, the soils in the area of concern were somewhere in the 19 to 24-inch range. There was a 24 and a 28, but those are actually off of the property now since the recent subdivision. I'm going to pass it over to Joe at this point.
Again, Joseph Melo. Just to piggyback on what Neil said, after reviewing the soils, the test pits that were completed back in 2015, updating the groundwater to the 19 to 24 inches, and also reviewing the soil categories that it was classified as Category 9. What that's going to do is really going to affect the size that the bottomless sand filters are sized to. So that's going to increase the size of the sand filters from about 800 square feet to about 1,022 plus or minus square feet. And then, so with the increase in size and the density of the site, it's just going to lead to more constraints to meet all the setbacks between the OWTS and the buildings and the stormwater. So it's something that should be looked into. And due to the soils and the groundwater, it appears that a variance is going to be required due to rules for the RIDEM OWTS Rule 6.33E. It's not a, just to summarize 6.33E, separation to groundwater can be reduced to between 18 and 24 as long as no variances are required and the design flow is below 690 gallons per day. So we've calculated with the density of this property and the units that it's going to be 4,600 gallons per day. So that's going to need a variance. Since this lot was created in 2018, under the DEM regs, this is considered a subdivision. And from my understanding, the subdivision was created making their own hardship. So it was subdivided, so now you're limiting the space. So it's hard to go for the variance when it was already created a subdivision back in 18. So stepping back there, so the OWTS standard 6.52E3 is an automatic denial if a septic system requires a variance if the property has been subdivided following 1995. I'm not DEM, but due to my understanding of the regs, it needs a variance, which it's been subdivided, so it should be automatically denied by DEM. Again, it needs a variance because the flow is high, it's been subdivided, so it shouldn't be allowed. The other issue is some concerns with the stormwater. Again, the same concerns from the septic design is the soils. So each of the units, it looks like on the blue dots behind each unit is supposed to be an infiltration system to handle.
You have a pointer there if you want to.
Oh, okay. So the blue dots here behind each unit is labeled as an infiltration system. I know they're not designed at this point, but an infiltration system is going to be a lot smaller of a system. Due to the soils, you can't infiltrate in these soil conditions due to the constraints from the soils and the high groundwater. So is it a solvable problem? Yes, but it's going to be a larger system, a surface system, and it's just going to further intensify the density of the development because you need to make a larger system which needs setbacks from the building and also the septic systems.
Let me just ask one question that's kind of relevant to that. On units 12 and 11, the septic system or whatever you guys call them there, are those, does the water easement and the fact that the applicant's requesting a 6-inch pipe or a second pipe within the water easement, does construction within the water easement, including a structure, would that affect the operation or the ability for units, for the systems to work on 12 and 11?
So I can't say I've read the easement specifically. I can only speak somewhat generally. Often elements are allowed in easements as long as it doesn't preclude maintenance on the easement. There are some separation distances between water and.
I was asking because
obviously, whoever the easement, the town's not the easement holder, but it was more separation between an easement or a water line and the ISDS system.
Right, and if they were infiltrating systems, that may be a concern to pick up with the AHJ. But if they change it to a closed bottom system, that's generally something that's acceptable with the AHJ. Since it's not actually leaching groundwater, there is some separation distance provided from the water line to the system.
And that would be an issue between owner of Lot B and owner of Lot A, because obviously owner of Lot A, has easement rights. Those easement rights may or may not allow, again, that was just dropped on me tonight, may or may not allow certain, encumbrances or encroachments into that.
Just a couple other components, just generally. I know that, again, I know it's not a full design, but just some of the thought process. They have the additional parking spaces, the ones in yellow here, were indicated that there'd be grass pave. No infiltration is permissible in the soils, like I mentioned previously. So the concerns with a grass paved area is obviously in the wintertime, plowing. They can be problematic for high use spaces. Usually these are used and more suitable for seasonal use or an overflow space for like a big sporting event or something to that nature. The plans don't show any provisions for stormwater conveyance for the roadway to get all the drainage from the roadway down to either the BMPs or the detention basin. Again, it's not that it's required a full design at this point, but the conceptual provisions in the conveyance is typically shown, just so it's been thought about and they know feasibly it will work. And also just to confirm that setbacks between the stormwater pipes and the septic system design could all be met. Again, it's just a finer detail, but usually just detention basins. This big pond here, it's going to need access to be maintained. I know we're not at that design level, but it's something that's going to be considered, that there has to be, if you have a BMP here and you have all lots here, how are you going to get there and maintain it? Just something else that should have been, in my opinion, should have been thought about and shown on the plan. Again, I understand the septic and stormwater systems don't need to be designed in the master plan, but the conceptual design needs to work and be thought through and shown conceptually. It's likely due to the soils that we confirmed, I don't confirm, but that were done in 2015 that were submitted and done by a class 4 soil evaluator, that the seasonal how groundwater is going to change the design of the septic systems and also make it impractical for the infiltration systems, that they won't meet the regs or the stormwater design manual. I think these are solvable problems for the stormwater, but due to the density, it's going to be difficult to feasibly engineer the systems. After speaking with some of the abutters, there's also some existing drainage problems within the neighborhood in conjunction with the issues that I previously mentioned about the septic and stormwater. It's my opinion that the applicant has failed to adequately address the standards with respect to stormwater management in the septic systems, respect to health safety concerns, particularly considering the neighborhood issues, previous issues.
There's been some reference to...
Step up to the mic, please.
I'll get that right. There's been some reference to some soil testing from 2015 or 2017. Is this a copy of the document that you were talking about?
Yes, it is.
I'd like to submit this as an exhibit.
Just for record, this is a good job.
No, but you're doing it so well, Mr. Brady.
Thank you, sir.
two. I think I have two.
If I may, I just want to reiterate that septic rule. It's kind of esoteric, for lack of a better word. But again, it's because the water tables are between 18 and 24 inches, a variance is required, right? We're over the 690 gallons per day by like an order of magnitude at 4,500 gallons. Often that's allowed, right? Variances from DEM are somewhat common. But again, our understanding is that because it was a created subdivision, denials are automatic, and I think Joe appropriately referenced the rules in that. So often at this stage of the game, one would solicit DM for an opinion for suitability of these systems, and often just make sure that the puzzle pieces fit together and that you can meet the appropriate setbacks with your OWTS and your stormwater systems, and also that there's no fatal flaws in this. So again, we're not DEM, we can't make that rule, we're just telling you what our opinion is, but it would seem appropriate that DEM was solicited for their opinion on this issue.
Thank you. Mr. Perry?
I have no further questions, Mr. Chairman. We have no other expert testimony. At this time, I would ask that you hear from members of the public, and then I would reserve just a brief few minutes to give a summation or closing at the end.
Well, first, if anybody on the board has any questions for those two witnesses, and then Mr. Doherty can respond to those two witnesses, and then we'll go to the public.
I just have one question. Do you guys have anything else you want to submit in evidence?
We do not. I think the testimony covered it.
Mr. Chairman, I'd like to call Eric Prevey to rebut some of the
So
testimony.
you're going to react to some of the statements?
Yes, just what was
Sure.
presented right now.
Good, okay, go ahead.
Good evening. For the record, and I don't need to be resworn, but
You're
some of the
sworn.
people have not been here in the past, so I'll at least introduce myself. Eric Prevey, a registered professional engineer with DePrete Engineering, offices at 2 Stafford Court in Cranston, Rhode Island.
Yep.
In response to some of the comments that were made tonight, I can start by saying that we're going to be happy to work with DEM and Coastal Resources Management Council at the appropriate stage at preliminary plan. I did get a chance to look at the soil evaluations that were provided as well. Looks like 28 inch, 24 inch, 24 inch, 24 inch, and then as it moves towards the northern part of the site, closer to an 18 inch. We, DePrete Engineering, also did the septic design for the house to the north there, and that, I believe, was also an 18 inch. So I can tell you, in regards to the sections that were cited for variances, we will not be seeking any variances from Department of Environmental Management. We believe we can site the bottomless sand filters with denitrification technologies on site, and will be adequately sized and suitably sized for this development as well. So we will not be seeking variances from DEM. As I mentioned, we'll be happy to provide the appropriate, at the appropriate stages as well. As far as some of the other items, the quote that I'm taking away from it is, I think all of these are solvable problems. So I tend to agree with that. I completely agree. Every single one of these are engineering issues that we feel we have good solutions to. Access to the pond. I mean, you can go straight directly from the cul-de-sac. So items like that, conveyance. I had mentioned as part of my testimony last Tuesday now, that the two entrance, the BMPs at the entrance were, because part of that we felt from an elevation perspective was not going to be able to get to that basin. So we provided a couple extra right next to the road to provide water quality treatment. Yeah. Oh, thank you. A lot easier with the pointer. Yeah. So these treatment here were for any area that can't get across from just an elevational perspective. So again, we'll be happy to provide all of that information. We are aware of the site suitability that was provided These soil test pits are actually still valid too, even though they were done in 2015.
Well, excuse me, that was a question I had. Mike, was that one that you had an issue with the date of these soil testing, or was that the water tables? Are these still valid, in your opinion?
I haven't spent any time really reviewing the soil data.
Okay.
It comes from the master plan for the original subdivision of this site.
Correct.
And the location of the pits that were done in 2015 in relationship to the proposed locations of the OWTSs and/or the stormwater detention facilities is uncertain to me. I only looked at the plans that DePreet submitted and realized that in key areas where they knew they were going to be designing and installing either a septic system, BSF, bottomless sand filter, or a stormwater BMP, best management practice. In 3 locations, there were no test,
Updated tests.
no test data. So I had asked for that and did not receive it.
And these aren't in there. This is from the original subdivision.
That's correct. That's correct. I can, Mr. Chair, if I may, can I
Sure.
speak to the whether or not they're still valid?
Sure.
Yes, they are still valid. Even though there's 2015, these were the soil test pits that were used for the subdivision suitability for that 3-lot minor subdivision, right? And as part of the regulations, I'm looking at the DEM regulations, and I'm looking at section 6.16B, and it's valid. I'll just read it real quickly. It's a real brief section. Validity of field data. Field data shall be considered valid for a period of 5 years from the time of an initial certification by the department, or 5 years from the date of initial approval of any OWTS application, design, or subdivision suitability, where the data was used, whichever occurred most recently. So the site suitability, the subdivision suitability was issued on July 23rd, 2019. So 5 years from that would be July of 2024. So it is still valid information, at
Okay.
least. So I just wanted to clear that up.
Thank you.
So, yeah, we'd be happy to, again, we'll work with the proper authority to ensure.
Okay.
I think there are steps to go. I mean, we're at the conceptual master plan stage, so.
We got that. Who do you want to ask? Sure. Mr. Privy.
Thank you. Yeah, not right now, it's not anyways. A couple questions for you.
Sure.
One, the issue has been density related to the site and sensitivity on it. Now, you guys your firm did a in-depth study on density on either side of Boston Neck Road, and you found one side to have 1.3 dwellings per acre and the other side to have 0.3 dwellings per acre. When I calculate that, you're looking at a maximum, an upward of 6 dwellings in this development, or 2 at the low, yet this is coming in at 20. Do you see any problems looking at all the zoning there, all the overlay districts that the town has put in over the years because of the environmental situation, the wetland situations, and everything else? Look at the surrounding actual development on either side. You're looking at a range of 2 dwellings to 8 dwellings. And we're looking at 20 on this site. And do you see that consistent with what's there now?
So I'll give my engineering answer is what I will give, right? Not from a zoning perspective per se, right? From a zoning, I tend to agree with Mr. Pimentel's. Zoning is a number that is.
Do
I'm
it
not
from
asking
the
you on the
engineer.
zoning, I'm asking you on the
Okay,
engineering.
so from the engineering perspective, we do feel that we can adequately and suitably provide stormwater, the septic systems, and all of the environmental treatments that are needed to support the 20-unit development. We do. We feel confident in that. And that's irrelevant of what the neighbors are. The neighbors could be on a 5-acre lot. The neighbors could be on a 10-acre lot. I'm talking about 20 units on the 6.1 acres. We feel confident that that's what we will be able to engineer that. We do.
So my question is on the 20 by 40 bottomless sand filter. That is to catch runoff, correct?
I'm sorry?
I'm sorry.
The bottomless sand filter?
So we have pointers.
Yeah, the bottomless sand pit
Point it.
there, the 20 by 40.
That is not for runoff. That is for a septic system.
That's for the septic system,
Yep,
okay?
that's a leach field.
That is a leach field for all of these individual units, okay?
There are 3 separate ones.
Okay?
Yes.
This
Yep.
is what I'm trying to get to.
Okay.
Yeah. Yep.
Yeah, I can.
Okay.
Mr. Brady, is it okay if I circle the
Yeah,
areas real quickly?
please.
Okay, cool.
Thank you. I'm just trying to clarify some things
Yep,
from my
sure.
own thought process.
So the bottomless sand filters are located right here. You can see, it's tough to see because the arrow itself is black and it's on a dark background, but the arrow's coming to right here is one of them.
Okay.
There's another one coming here, and then there was another one that's located over here as well. So these are the 3 conceptual septic areas.
Okay. And so, and then these leach into those. So, I'm sorry. This is a drainage basin for what?
Stormwater runoff.
All the stormwater.
Stormwater runoff, yeah.
Okay, and then these pits are for septic,
Yes, for sanitary sewer, septic,
All right.
on-site septic, yeah.
on-site septic, for all of these units?
Yes.
Okay?
3 of them.
3 of them. Now, if any of these fail, is there a backup plan?
It's the same as any other system in town. It would be, these sand would be removed, it would be replaced. That's standard, that you don't have alternate systems. At one point, there was alternate systems in private welled areas. You would have alternate systems. They don't do that anymore. And this also isn't a private well area. This is a public, this will be municipal water, so there's no need for an alternative. They found the reason for that was because people were literally replacing it in the same spot. They were removing it and placing it, not moving it to an alternate location. So no, we do not have alternative locations here.
And these individual units have their own individual unit?
Yeah, they'll have pretreatment units. Yeah,
Okay.
exactly. So they'll have the Advantex septic tank with the pretreatment right at the source there. So each duplex will have one Advantex pretreatment denitrification unit, get the treatment right there, and then it has a pump that will go to the bottomless sand filter.
So each unit has one, each building has one?
Each unit has one pretreatment unit, yes.
And are
So there'll
those
be 10
sized based on
pretreatment
bathrooms, based on occupants, based on bedrooms?
Bedrooms, yep,
Bedrooms.
yep. These are all 2-bedroom units, so each one would be for 4 bedrooms.
Okay.
And just to be clear, there was a reference to building and unit. I want it just to be clear that each unit will have their own system,
I
correct?
believe he
No,
said
actually,
each building.
The building will, so because each unit is a 2-bedroom unit.
Right,
So each building has 4 bedrooms.
right.
A 4-bedroom going to a standard Advantex AX20 is very common. You have 4-bedroom dwellings all throughout town, and that's what they use as the AX20 units.
You and I were doing good. Thank you, Mr. Chair.
Thank you, Mr. Brady. Anything else? Thank you, Mr. Privy.
Thank you.
Okay. I think we're going to go to the public now, Mr. Doherty,
I
but
think so. I think that'd be great.
you're all done? Okay. Okay, so here's what we're going to do, folks. We're going to, wait a minute. So we're going to go to the public. You want to take a break? Okay, we're going to take 5, and then we'll come back and I'll explain the ground rules for the public. Oh. Yeah, I know. I know they collapsed. I was on the phone, and they collapsed. Okay. Thank you. I'm going to call the meeting back to order. So at this point, we're going to go to public commentary. I need to allow anyone in the public who wishes to speak. You need to be recognized by the chair. You need to be sworn in by the stenographer. You will have 3 minutes to give your opinion, support, opposition, whatever position you want to take relative to this proposal. I'm going to be keeping track of time. Like I said, we have to get through everyone. This is an opportunity for you to make a statement on whether you support or oppose this proposal. It is not a question and answer between you, the public, and the applicant or their experts. If you have a question, you can pose it to the board. If one of the board members chooses to answer it or to seek clarification from staff or one of the experts, they can do that. But we're not going to go back and forth between the public and the applicant. So if you have a question, address it here. But primarily, give us your opinion, up or down. Within the 3 minutes, I would like to thank the public for all the communications. A lot of people took time to write and made they organized their thoughts and made their arguments in the communications to the board. And I assure you, the board's read all of them. All the members have read that, so that's all part of the record, and it's all part of what we're considering when we make our decision. So let me get my...
Yeah, I would thank everybody. Probably some of you people wrote to us too before you speak, and I know it takes an effort. And they're very, very good, very concise, very pertinent. Thank you.
And it should...
I would just like to add that the letters that we received were non-emotional. They were based on fact. A lot of research, a lot of work went into things, brought up information that I was able to further research and prove or disprove to my own satisfaction. But it's nice to get stuff from people that did work and not just threw things out there. So thank you.
And if you took the time to write, summarizing your thoughts in 3 minutes should be easy because we have the detail of what you wrote. So who would like to speak first? Yes, sir. Come on up and be sworn in, please.
Thanks. I do. Michael Natalizia, N as in Nancy, Atalizia. Thank you. You're welcome. Hey, board members, thank you for letting me speak. I have submitted formal documentation in opposition to this development, so I won't go over any of the points in there for brevity. But one point I'd like to make that sort of came up tonight that has some pertinence is that, so I'm in a butter to the south, 500 Old Boston Neck Road, and we had to put a new septic in to replace a cesspool that was antique. So we've done all these studies, and we have the AX20 as described by the engineering firm for the applicant. And I just want to say that we have a bottomless sand filter that is 800 square foot in size for 8 bedrooms. So if you apply that to relatively what I see here, there's no dimensions, they do look on the small size for 40 bedrooms. The deed stuff that I found the other day has been talked about, so I won't delve into that. I do have a question about the easement, though. The easement is in my deed, and I imagine in the new deed that will be submitted. It's not in the current one that's filed. And it mentions that the deed needs to be maintained by, the easement needs to be maintained by us. So I'm assuming that that means that if that pipe breaks or something, that we've got to fix it. I'm not sure how that plays into the new easement or the new parcel where the easement goes through.
Let me just hold you there.
Yeah, sure.
Do you have Mr. Marcel?
So normally I don't do this, but because it's more public comment, but
Yeah, sure.
as the easement holder, you have certain rights. You should talk to your closing attorney or get those documents from your closing to determine what your rights and responsibilities are or not within that easement.
I see.
Okay.
Thank
Okay,
you.
Very good. I mean, the deed is very terse about that, so it's hard to tell. Let's see, the last thing I'd like to mention, well, there's two things. The potable water source that they're planning is potable water source, the drinking water that they're planning to feed the 40-bed, potable water source is actually a North Kingstown source. It's an artesian well-based system. I've lived in the North End for about 25 years, and I've seen the system definitely get depleted in certain years and reach contamination levels. So it's reached its capacity. So I would question whether or not the applicant has gone to North Kingstown to find out if they would be even willing to add 40 bedrooms to that system. But I thought I'd bring that to your attention because it has been a source of issue. And lastly, I'll just say that, living here, these are wet lots. I've got almost 2 acres of wetlands on my property, and 7 or 8 months a year, we're slogging through what looks dry, but it holds a lot of water. It's all like a sponge. My dog's happy because he gets to flounce around in it, but other than that, it's kind of a nuisance. So seeing a development of this density, so close to the 2 properties nearby, as well as the wetlands to the east, I just don't see how that will be managed. So that's my last statement. Thank you.
Thank you, sir. Appreciate it. Good job on the time. Who's next? Wait a minute. Sir, you need to be sworn in.
I do. My name is Earl Jackman, first name Earl, E-A-R-L, last name Jackman, J-A-C-K-M-A-N. Yes. Good evening. Thank you, members, Chairman Fleming, and the members of the board, attendees. I am all in favor of affordable housing and additional housing in Narragansett, but I am not in favor of my basement being flooded. And it's not unsubstantiated. 4 of my neighbors have had flooded basements in the last several months, requiring them to pump water out into the street. In the winter, that water freezes and makes any type of traffic, be it automobile traffic, pedestrian traffic, or even horse-drawn carriage traffic, very hazardous. And this has been a significant problem. The experts here, and I'm certainly not an expert, but our experts here are very uncertain and unsure about retention pits. And I have a huge retention pit in my yard, taking about 15% of my property, that actually has a swale that empties my water from that retention pit out into the street and then on into the bay. But I don't see any swale with this huge retention pit that I'm looking at there. And of course, the complexity of the septic system speaks for itself. And that certainly is a concern for my friends with wells for their water needs. By removing acres of pervious surface at the top of the hill in the West Passage, it's only logical that the neighborhood itself will be more subject to flooding than it already is. Zoning rules are made to protect the environment and provide safety for the residents. They should be enforced, not circumvented. I do have some photographs of the area with standing water from a recent, well, not recent, but back in January now. If the planning board would like to look, I don't know how to handle this
You can submit it, and we'll get copies to Mr., you want to take a look at them? Show them to Mr.,
Whatever I'm supposed to do. No, just a quick look and then.
yeah, Mr. Doherty will pass it on to us. We'll watch them closely. Thank you. Thank you, Doctor. Appreciate it. Okay, who's next? The gentleman in the back? You need to be sworn in, please, sir.
Hi. I do. My name is Matthew Foley. My last name is spelled F-O-L-E-Y. Good evening, Mr. Chairman, members of the board. My name is Matt Foley. I live at 600 Old Boston Neck Road. It's Plat NB Lot 30-2, as everyone can see in the northernmost corner of the site. The current comprehensive regulation of zoning lot sizes is to be proportional to the zone of record. And R80 residential low density was deemed to be the most appropriate by this board back in 2019. This proposed major land development is high density and obviously non-conforming. In fact, multifamily development requires 10 acres in R80, and the proposed development falls 40% short. I submitted a report back on March 27th to the board. It was a 19-page report. I'm sure everyone has seen it, regarding health, safety, and environmental impact of the proposed development. The project's will likely reduce critical pervious coverage by 1/3 of the site and add stormwater runoff to a variable width country road with poor existing drainage infrastructure. You'll hear more about that from my neighbors tonight. Runoff that will contain non-source pollutants, including nitrogen, phosphorus, and fecal matter, making its way into Narragansett Bay. Low-impact development and BMPs, in this case drainage swales and detention ponds, are not appropriate for areas with high groundwater. In this case, Zone B, a high water table limitations overlay district with existing periodic flooding. The property owners on Old Boston Neck Road, those living downstream in Saunderstown and in West Passage will be impacted by the increased nuisance stormwater and increased winter ice hazards. I'll slow down. The potential also exists for the contamination of private potable well waters abutting and downstream of the proposed development. Now, regarding health and safety, Town Ordinance Section 174-111 declares there's no through trucking on the street among only 5 roads in town, and the right-of-way is granted to horse-drawn carriages. And I'm curious why such designations were made. Was it the road width and speed? Was it vehicular incidents history? We heard from Beta's representative Paul Bannon tonight talk about a traffic study that occurred in September of 2022. Clearly not a reflection of peak season traffic volume, and it also doesn't consider the upcoming expansion of the URI campus voted upon by our constituents. In fact, there's been 4 vehicular accidents in the last 2 years at the hazardous interchange of Minor Road and Old Boston Neck Road. I don't know where the data from 2017 and 2019, the date range was found applicable, but 2 Rhode Island energy poles were replaced in the past 2 months in front of my home.
Mr. Foley, you need to wrap it up soon.
I'm sorry?
You need to wrap it up soon.
Okay. A local kid struck a pole, totaled his car in front of our home on March 23rd, North Kingstown Report 23-189-AC. Another vehicle took out a pole on January 9th, North Kingstown Report 23-20-AC.
We're at over 3 minutes, so.
Thank you for your time.
All set. Thank you.
I would, absolutely.
Yeah, you can submit that. Thank you.
Thank you.
Who is next? Yes, ma'am. You come up and be sworn, please.
I do. Barbara Mariconda, M-A-R-I-C-O-N-D-A. Speak as quickly as I can.
Go ahead, ma'am.
I'm here as an expert witness on the proposed Old Boston Neck Road development. While I'm not an engineer or a wetland specialist, I do have firsthand experience at the heart of this matter. I live on Old Boston Neck Road, and I spend my days 24/7, 12 months a year there. I ask that my firsthand knowledge and legitimate interest as a taxpayer be taken seriously as you consider the future of the neighborhood that we all love. There are a total of 10 homes on Old Boston Neck, 9 of which are in Narragansett. This development would more than double that number. To suggest that this would not have a significant negative effect on the environment, traffic, and character of this beautiful historic neighborhood is ludicrous. I can attest to the fact that our charming, narrow, curving road without sidewalks or curbs, much of which runs along a culvert that prohibits trucks, is used by horse-drawn carriages, those on horseback, cyclists, parents with strollers, and dog walkers. I've often pulled my grandsons in a little red wagon to visit the farm down the street. Even after recent trenching to control drainage, two-way traffic is impossible when pedestrians are on the street. It causes cars to stop in both directions. Any rain event results in flooding along my property, requiring me to wear boots to collect my mail. I'm extremely concerned about the density of this development, the amount of impermeable coverage, and its impact on our water issues. I understand a traffic study had been done. Clearly, it was not during the peak summer season when beachgoers use our street as a cut-through backing up onto 1A. Or not during shift changes at the Rogers plant when scores of cars and trucks speed down Old Boston Neck to avoid lights on South Ferry. These are already issues without the additional 80 cars. We're hearing lots of promises about the care with which this proposed project is being developed, all the testing and engineering, but all of that is only as good as the implementation. Unfortunately, Green Hill does not have a great reputation in terms of implementation and follow-through. Online reviews reflect this. Here's one. Upon completion of a new construction on a property adjacent to mine, I was promised the shared drive would be fixed upon completion, but the material used was non-permeable and crowned the wrong way. Now water runs off onto my property, flooding it. Calls and emails go unanswered. So should this pass, and there are similar issues, who's responsible? The owners of the abutting properties, the town, the developer, and if past behavior is any indication of future behavior, as it generally is, Green Hill's project does not bode well.
Ma'am, 30 more seconds, please.
Okay. Lastly, it's true that these low to mid-income units is it true that they maintain their status for just 5 years and then can be sold at full market value? If so, that would mean the total disruption of our neighborhood for a minimal, less than 1 percentage point increase toward affordable housing goals, and lasts for only 5 years.
Wrap it up, please.
I'm all in for affordable housing. Put in 3 affordable units, period, and we're all good.
Okay, thank you. And just to clarify. Do you have anything you want to submit? Wait a minute, just to clarify, the affordable units are in for what, according to the application? She couldn't hear the question. I'm sorry. The affordable units would be affordable for?
As low as 30 and as high as 99 years. I don't know if they've submitted anything yet.
The LOE, I believe, referenced the minimum of
30 years. So they have to be 30 years. They could be as much as 99.
Oh,
Not,
okay.
not 5.
I heard it was 5.
It will,
No.
My
under the law, it
apologies.
can't be, it has to be at least.
State law is minimum of 30.
Thank you.
There you go. Great. Who's next? Thank you, ma'am. Who's next? Anyone? Gentleman in back.
I do. Thomas Halavic, H-A-L-A-V as in Victor, I-K. K.
And you submitted a letter too, correct, sir?
Yeah, I was, should I paraphrase it or read it?
Yeah, no, we all read it. If you want to summarize it to get your comments on
Well,
record,
okay,
but
so-
we do have your letter. Thank you.
My wife and I own property and we're abutters, and kind of the theme of my letter was water flows downhill. Right now, the situation is that property drains into the ditch, and as in the testimony last week, there are 2 culverts that convey it east, and it crosses and eventually ends up joining at my property and goes across my property and then through the hazard property and down to the bay. And there are times when the frequency of the road actually flooding and overtopping happens. And we are very concerned about the ditch and the culvert system not being able to handle the overwhelming amount of water that will result from this project. Again, when I looked at the development on the back of the envelope, it looked like there's about 80,000 square feet of impermeable surface in a 6-acre. So that's a third of the area that has to be dealt with. And yes, there are engineering ways to do this, but it seems with the water table where it is, it would be very difficult to actually achieve this in this kind of density. The other important part is everyone living to the south and east or downhill has to provide their own water through individual wells. And we worry about when the road gets overtopped or something during a storm event, that the pollutants from the road itself and any of the salt treatments or anything during the winter just gets washed into our wetlands, and hopefully the wetlands can handle it, but at some point, there's just too much is too much. So, and then my other sort of point was that possibly that whole ditch system that the town recently cleaned up actually is and works like a wetland. And I was wondering under the present regulations whether or not that pretty much, I mean, you drive by, it's skunk cabbage all the way up to the stone wall. I mean, that's a functional wetland. I think it's been totally overlooked in terms of the design of this property.
Okay.
And you know, and will the ISDS work 100% all the time? If not, you're conveying this water down through my property and the hazards and into Narragansett Bay, and basically, you know, you're promising all of us that the bay is going to remain clean like it is now. So anyway,
Okay.
I
Can wrap it up now, sir.
I'm fairly opposed to this. I am not opposed at all to affordable housing. I think we have to make a better effort of trying to identify those areas that are easier to develop for developers so they can make their money and we can get the housing we need in this town.
Okay. Thank you very much, sir.
Thank you.
Appreciate it. Little microphone maintenance by Mr. Doherty. Good. Good. Who's next? Over here. Want to be sworn in, please?
I do. Nancy Moskwa, M-O-S-K-W-A.
Ma'am, excuse me, before you start, we received your letter. Please try to confine
Oh, I
your
will.
comments to this proposal and
I will.
not some of the other issues.
I
Thank you.
definitely have done that. I signed a contract with Dave Rogers to build a 20 by 40-foot in-ground pool on October 24th, 1999. I explained that I had a significant water problem. He poured the foundation in November of 1999. He said he would complete the pool in the spring of 2000. I have pictures taken in February of 2000. This is a 20 by 40-foot hole in the ground, completely full of water. The west wall of the foundation is broken in half in the center and slid in 4 feet toward the east. Dave Rogers was a fully licensed Rhode Island contractor. I signed a contract with Frank D'Andrea on 9/9/2000 to remove the old foundation and build a pool. He was well aware of my water issues since the broken foundation was still in my yard. He said he could handle the water problem. Frank D'Andrea was a fully licensed Rhode Island contractor. Since then, I've had 2 problems with water. After a heavy rain, my backyard is like a very wide, very shallow river.
Slow down a little bit.
Heavy rain. My backyard is like a very wide, very shallow river. Water flows downhill from west to east. This water would fill my pool and float the liner. I put perforated pipe on the west side of the pool to divert water away from the pool. Water would shoot out of that pipe like a giant fire hose. The second problem was the amount of water that I had underground. The vinyl liner would bulge because the water pressure on the outside of the pool was greater than the water pressure inside the pool. The liner would pop out of the attachments around the rim of the pool. I have multiple pictures of my family and friends resetting the vinyl liner every year in the spring when we opened the pool. Ironically, my pool is now ruined due to water problems. 2 fully licensed Rhode Island contractors failed to manage the water that plagues my property. Rainfall collects on my property and does not drain. Rainfall forms small ponds that are large enough for ducks to swim in. The damage to my pool tells me that significant water is moving underground on my property. Since the West Passage neighborhood is all downhill, I believe this water ultimately ends up in Narragansett Bay. I'm a retired software engineer. I was the database administrator at the Environmental Protection Agency, so I'm going to get a second opinion. My colleagues at the EPA on South Ferry Road know who to contact in DC. I'm hoping that when the EPA finds out that Rhode Island thinks it would be a good idea to build a giant septic system on wetlands at the top of a hill that drains into Narragansett Bay, they will be interested in this project. My life will not be improved by this project. I'm 69 years old and I just want to retire in a quiet neighborhood, no traffic, no noise, no flooding. I would like to be able to continue to walk around the block, which will be far too dangerous with high-density traffic and no sidewalks. I've lived in my house for 36 years and I've been planning to retire in my house for 36 years. Right now, there are 49 states out there that I like better than the state of Rhode Island. Thank you for your time.
Thank you, ma'am. Who's next? Someone over here?
I do. Barbara Halavik, Halavik.
I'm sorry, you submitted an email or letter as well, too?
I did submit an email,
Okay.
but I would like to read it. That's the
Sure.
most concise way I can do it. Thank you for hearing me. I'd like to add my voice to the numerous concerned local residents opposed to the proposed land development on NB Lot 30A. Having lived in the area my entire life, which I won't specify, and owned vacant 5+ acres within 200 feet of the subject property, I'm very familiar with the area. In particular, the high water table and the rural country back road that is precious to all that travel it. When first purchasing our land in 1978, it was zoned R40. Narragansett changed that to R80 to preserve the rural feeling and to be respectful of the sensitive ecological nature of the area. When first learning of this project, which was just this March 31st, I was stunned and appalled. Not because affordable housing was proposed, but because of the sheer density of the project. I always believed zoning existed for a valid reason. 3 2-acre lots made sense to me. The developer is playing the affordable housing card. Affordable housing is like a magic word. I do now understand the state of Rhode Island has made this possible for you, the board, to ignore the R80 zoning. But can you truly ignore the impact this density will have on the area while adding insignificantly to the town's percentage of affordable housing? It will add greatly to traffic, groundwater, and light pollution. Nobody's mentioned light pollution. We need to think about dark sky. And it will destroy our rural setting. There are no duplex one-story condominiums on Old Boston Neck Road. It's because the existing zoning doesn't allow it. It's hard to believe that the owner can't be satisfied with building 3 houses that the land supports. Not to mention the abutting neighbors were told there would be no more than 3 homes allowed by zoning. It's unimaginable the impact on the loss of value the abutters will suffer if you approve this project. My own property, which will receive additional water, will also suffer loss of value. The chance of that water being contaminated is greatly enhanced by the density of this proposed development, all of which can end up in Narragansett Bay. So how do we move forward? Deny the proposal in its current form, require the developer to drastically reduce the density, require the developer to access the development from Route 1. If the state is not in favor of this access, then remind them that they're the ones mandating affordable housing. They need to support what they preach. Access from 1A would lessen some of the safety and water issues as well as the aesthetics. In addition, it should be noted the access road, called a driveway by the developer, is ridiculous, has to cross a wetland that developer and his experts have failed to identify.
Ma'am, please wrap it up, thanks.
For now, just deny the proposal. The town of Narragansett needs to determine appropriate locations for affordable housing. And a closing comment, I'd like to say I find it really sad that the town has forced a group of citizens to hire an attorney in order that we can mount any sort of a chance of opposition. We can't even ask a question without losing our ability to speak at another meeting. Please put your wisdom and empathy and deny this comprehensive development. Thank you.
Thank you. Who's next? Someone? Anyone else? Hearing none? Oh, no, someone jumped up. Well, I could use some hands in the air if you want, you know.
I do. Cheryl with a C, and Merluzzo, M as in Mary, E-R-L-U-Z-Z-O.
And just for the record, ma'am, you submitted a letter as well,
I
correct?
did.
And we
I have
that.
some additional pictures
Have
since.
it. You want to,
Some additional pictures.
you could show the attorney and then I'll wait to start the clock on you.
Can I pass them on to you as well?
13.
Thank you.
Thank you, ma'am. Go ahead.
I'm not in a butter, but I put my hand and feet on that road every day. I'm very concerned about the safety of pedestrians, bicyclists, horses, anybody who's on that road. I'm trusting that you will deny this density part of this project because of safety. To get a true feeling of this road, you need to walk it. When you're there, you're not sitting in a truck just sketching off how many people came by. But I'll tell you, when you're there and you're walking it, you know how dangerous it can be. It's a very thin road. It's actually a country road that's been paved. It has no shoulders at all, and ditches on both sides. One has maybe, everything's an angle. You can't walk into it at all. Traffic comes by from the ever-expanding Bay campus, as well as the industrial area. And at this particular off-season time, we are maxed out for safety currently, without adding anything else to it. When traffic approaches in either direction, it becomes a nightmare for walkers, their dog, their children, the joggers, the cyclists, the runners. Not all drivers are very courteous. You can't count on them being courteous. Not to mention the excess speeds that people will travel. This is no place to go when cars are coming in either direction. It's a nightmare. It's an accident waiting to happen. It's already a dangerous intersection that other people have remarked about. It's a difficult corner to take from Route 1A. If you increase the likeliness of 40-plus cars, you will certainly get more worse than it's currently at. It will be an area that we pay taxes that we wish to, and this project will deny this right for the fear of our lives. I am not in favor of the density of this project. Building singular homes would be much more favorable for the taxpayers, neighbors, and the integrity of this area. This is a historic road to Narragansett, and this type of cluster density homes will destroy its authenticity as well. Thank you very much.
Thank you for your time.
Thank you.
Anyone else? Hands? Yes, sir.
I do. Willie Yando, Y-A-N-D-O-W.
Mr. Yandy, you also submitted a letter.
I did submit a
correct?
letter, and in brevity, I will paraphrase it, you know.
Perfect, thank you.
Two things: concerned about the safety of the road, that's in my letter. The second thing is, just for point of reference, in the Hurricane Bob, so I live at 450 Old Boston Neck Road. Mr. Halavec spoke of the creek, and the water runs from the west side of Old Boston Neck Road, over the road, crosses his property, then turns and heads behind 465 Old Boston Neck Road, where it begins as the stream. Just as a point of reference, my driveway washed out from the flow from that stream, just on natural water for Hurricane Bob, stranding the two residents, 449 and 445 Old Boston Neck Road, which becomes a true safety issue until that road was refilled. So there's a concern that our driveway has washed out before, and with additional runoff, it is a safety concern. And third, I've been married to a hazard for 30 years, so I'm representing the Hannah Robinson House. The Hannah Robinson House LLC is opposed to the project, and they also are a well property.
And they submitted a letter as well.
And Mr. Hazard submitted a letter.
Yep,
Correct.
we have that.
Thank you.
Oh, thank you, sir, appreciate it. Okay. Anyone else? In the back.
I do. Amanda DiRenzo. It's Direnzo. Never done this before. I don't like speaking in public. So I'm
Relax.
just going to tell you some thoughts. I sent you guys a letter. Did you guys get it? Last night? Last night? Okay. Okay.
Yes.
So I
yes.
just wanted to, we moved into 600 Old Boston Neck Road about 3 years ago. We actually moved from one of Mr. Santelli's houses that was a new build in Pettaquamsket Lake Shores, and we needed more room for the kids. We have two teenage daughters. And we bought 600 Old Boston Neck Road, and we moved in, and I thought we needed room for them to run around, but I didn't realize that the entire property is soaked. They cannot run around in the backyard. They cannot play in the front yard. They can't even go on the street because typically it's flooded. I was out there today. It's dry today. I was out for a run, and the road was still wet in front of the hazard property. We get a lot of water that comes down from North Kingstown. There's a big pipe that goes under 1A, and it just floods our property. It keeps going. The kids call it a lazy river because it doesn't always keep flowing. It gets held up along the way, and then it floods the street, so much so that since January, we had 2 accidents, as my husband told you. Two totaled cars out front of our house. The drivers both said that they had hydroplaned on the water that was on the road, and they took out, ironically, the pole that they had done the traffic study on. That's, if you look, they had to replace it. Also, another pole out front where it meets Minor Road. What if my kids were out biking, or the neighbors were walking, or someone was pushing a baby? As it stands, I've said to my husband that we need something to slow down the traffic. And then when he told me that this was going to happen, I thought he was joking. I had no idea that this is something that would have ever happened there. When we moved there, we knew that there was going to be 3 houses. We were going to have 3 neighbors. Great. My kids could have friends. This is, I don't know, asinine. So that's my thoughts on that.
Thank you.
Thank you.
Appreciate it. Saw somebody else's hand back there. Anyone else? Nope. Oh, yep, way in the back. You can be sworn in, sir.
I do. Richard Santo Pietro, SantoPietro.
And you submitted a letter too, didn't you, sir?
Yes, I submitted a letter to this morning, and I wrote a letter to local papers
No,
some
but I
time
mean,
back.
for our record, we've read your
Yeah.
comments, so if you could summarize them, that'd be great.
Yeah, I really don't have to summarize. I have a few other thoughts that are in addition to what
Okay.
I've already written. And I've heard a lot of facts tonight, opinions, and perspectives and emotions. And I would like to just add a few of my own. Hopefully, they'll be a little different. I've been enjoying Narragansett for more than 70 years. My family brought us down to Lido's and Olivos Beach in the 40s. And I have been in touch with what has happened in Narragansett since then. I've owned property at 3 different places in the north end of Narragansett. And the thing that I have in common with those properties is water. One thing that I wanted to state in terms of condo development, the ones that don't make it don't vanish. They continue to create problems. And if anybody is interested in details, I can fill them in. Problems that go on for years. Problems that require maintenance on a continuous basis. All these engineers tell us detail. I haven't heard a whole lot about maintenance. Who's going to do it? How much it's going to cost? One thing that I'm really afraid of in seeing what's happened to Narragansett, both the good and the bad, if a project such as this is approved even with some tweaking, my fear is that it's going to set a precedent for all of the remaining open areas in Narragansett, be they suitable for building or wetlands. Thank you for hearing me, donating all your time and effort.
Thank you, sir. Okay, anyone else? Nope, no hands up, okay. Appreciate it, folks, appreciate all the letters, all the commentary, and now I think I would open it up to the board and Mr. DeLuca to pose any questions or make any statements they want, or any questions to the experts on either side of the table, and then after that, we'll go to a decision if our council says it's time to go to a decision. Mr. DeLuca, did you have some comments?
Well, as you know, Mr. Chairman, I have written you 2 reports. Just re-reviewed them both. First one's 15 pages, the second one's just a few. I can summarize them if you'd like. I do want to emphasize that everything that I've said in my first memo, I stand by. I haven't heard anything from the experts that spoke on behalf of the applicant last week or this evening that changes my impressions of my concerns.
I think, Mike, that we know we have your commentary on each of the elements that we have to make a judgment on.
Mm-hmm.
So I prefer maybe to talk about your update today, unless there's something really, without going through the other one all the way through, just if there's something that you think is critical that may have been missed, but I think it's going to come out, certainly going to come out in our decision, because we have to hit those standards one way or the other
Well,
when we make our
okay.
decision, so,
You and I've had this discussion before tonight.
many times.
I do want to point out a few things, procedural things.
Yep.
One is that, as you saw in my first memo, this application came in 3 parts, starting in late November and finishing in middle January. And even after that third submittal, which articulated the 7 areas of relief requested, I was still not satisfied that the application had reached a level of completeness. I sent an what I thought was appropriately worded letter to the applicant's attorney. He disagreed with me. But I really felt as though here we are at the master plan stage. This is the informational hearing. This is the opportunity for the give and take between the board and the applicant, between the board and the public, in any development in town, not just this one. The informational hearing is intended to share information. That's why they call it an informational hearing. So I had asked in my letter, I believe it was in early February, to receive additional information on the wetland edge, which is to date, as far as I know, has not been verified by CRMC. It was certainly not verified by CRMC in February because, as you recall, Mr. Privé explained at the meeting last week that they were doing some work on it in late February. So that I felt was absolutely necessary. I will tell you, and I know you and Dr. O'Neill have been at this for a long time, we have never had a master plan come to you which did not have a verified wetland edge. It states in the state law that a wetland edge shall be submitted to the town. I pointed that out to the applicant's attorney in my correspondence. Nonetheless, they did not submit that to us. I also, in response to the town engineer's concerns about water table and soil qualities, asked that the information, and as you can see here, this is a very busy map, the map of the site without the development on it. Whoops, excuse me. I just have to redo this. Is also quite busy. It was very difficult to find where the soil, water table tests had been done. I did find some, but they were not located in the vicinity of where the septic systems and the stormwater basins were going to be located. They were located, the ones that were noted there, in the areas from 2015 when the applicant was looking at doing 3 house lots. And they didn't give us even all that information. It would have been very easy for them to do a little bit more work in the field, put some holes in where they knew they wanted to put the septic systems, as well as that very large stormwater basin that shows up in blue on the map there, and verified for us how deep the water table is. Clearly, you folks have been through this before. If the water table is 18 inches, you only have 18 inches of soil to put stormwater in. You only have 18 inches to put wastewater in, unless you build an elevated bottomless sand filter, which I know can be done. But the engineering department asked for that. I passed that along to the applicant. The applicant chose not to give us that information. So what I'm saying here to you is the information that we needed has not been received. And as you know, to date, I have not written a certificate of completeness for this application. We allowed this hearing to go forward because Mr. Doherty and I knew we were not going to agree. But if I had to do it again, I would have stood my ground. Moving along. At your pre-application meeting back in 2022, and at my pre-application meeting with the applicant several months before that, both I and you expressed issues with density. The applicant reduced the density by 1 unit, and that 1 unit was a low mod unit. I found that to be ironic and not a very, I think, appropriate decision. We've heard from between last week and this week, we've heard of several glitches, and I know that's not a technical term, in the application. Not only what I just mentioned in the last few minutes, but the deed issue, the issue with the water easement. Mr. Natalizia spoke about the fact that he owns that easement. These things should be worked out. This information should be provided. And it was easily ascertained. It wasn't something that was going to be costly, and it wasn't something that was going to be time-consuming. Moving on, this application was sent to the Conservation Commission for their review. Every major development goes to the Conservation Commission.
Yep.
Not surprisingly, they raised concerns about density of the development, the size and the capacity of the OWTSs, just as the engineering department did. The engineering department is saying, how do we fit the water in there when the water table is 18 to 24 inches down? They were concerned about the slope of the site and the direction of drainage. They were concerned about natural vegetation. They wanted to see a conservation easement over the site, landscaping, and they were concerned that the roadway, if we're going to have all this other impervious surface, the roadway could be constructed with pervious pavement, at least to reduce the issue of stormwater management to some degree. The CRMC staff was sought out. In phone conversations in January, I spoke with two members of the staff, and they pointed out that a new wetlands edge verification would be needed because the wetland edge identified on this plan goes back to 2018, and wetland edges are only good for 3 years. In doing the required findings, I found that in regard to the comprehensive plan, I found that this application is at least partially consistent with the plan. I concur that affordable housing is a goal of the plan, and this is an affordable housing development meeting the state definition where it has it proposes 25% affordable units, 75% market units. 25% is the minimum under the state law. They can go higher, but this applicant did not. They provided an explanation that the density of this property would be 11,173 square feet per dwelling unit. Therefore, they need 68,827 square feet of relief for each unit. In reviewing Mr. Pimentel's land use report, I found many questionable comments. He asserts that there is limited townwide remaining developable land, but he doesn't buttress that by telling us where it is, how much there is, just that it's limited. He also states, as someone here on the board mentioned, that there's almost non-present physical limitations. But when I put up, excuse me again, when I provide you with this information, you can see that all that brown area, light brown as well as dark brown, is high water table. The blue and the two shades of blue are wetlands. Now, they are not site-verified wetlands. Those are wetlands from aerial photography, so we can't be absolutely certain how large that is. And as you can see here, the left side of the screen shows blue lines in all those streets west of Route 1A. Those are sewers. You see no sewers on the east side of this parcel. So in terms of physical limitations, I think we have several. Mr. Pimentel also criticizes us for only having increased our housing, low mod housing inventory by 1/3 of 1%. And therefore, due to lack of greater progress, suggests this proposal should be well supported. This simplistic perception provides no justification for the density. If this were the very last site on town, maybe you'd say, okay, we absolutely have to do this here. But he does not back up his commentary. He just states those comments and leaves them out there. For the record, I am refuting that. And I will get into that later when I go through my supplemental memorandum. He also states in his report that the waivers requested are well supported by the comprehensive plan, although those waivers were not yet articulated in formal request until January 23rd of this year. His report was written in December. My next commentary was on the pro forma, but I think you folks have addressed that quite well, so I'll leave that alone. Moving on to findings of fact, other findings of fact. In regard to the zoning ordinance, the lot is conforming with the zoning ordinance. It's not proposed for subdivision. So it meets condition requirement number 2. Requirement number 3 has to do with negative environmental impacts, which we've heard a lot about tonight. But it does, requirement number 3 speaks to the final plan. So giving the applicant a little bit of leeway, we can't hold them responsible for solving all the environmental impacts at master plan stage. But we will say that we are in a high water table district. I showed that to you a minute ago. And while they've provided 6 test holes, 2 of those do not have water table data. And some of the areas that we're going to have, as I mentioned a minute ago, either stormwater management facilities or wastewater management facilities did not have test holes. Why would you put test holes somewhere where you're not going to be putting the water? Moving on. I mentioned already, following my report, as you know, I mentioned already the wetland edge has not been submitted. But staff wants to remind the board that we have new wetland regulations. The setback now from the wetland edge is 75 feet. It used to be 50. And DEM, or CRMC in this case, has authority over an area within 100 feet of the wetland edge. The jurisdictional area is what they call that. Staff notes that 3 dwelling units are proposed to be located within the new 100-foot jurisdictional area and very close to the new 75-foot wetland setback. If the wetland edge has moved even 15 feet from 2018 when it was last verified, units 10, 11, and 12 would be over that line and will need relief. Also, the previous site plan, and it was noted by the objectives engineer, showed a small wetland on the northeast corner of the property, which doesn't show up on this plan. Again, if that wetland area is confirmed and verified as being there, units 1, 2, 3, and 4, right here at the front, may be in jeopardy of being too close. Being too close, excuse me, I'm sorry. Moving on, condition number 4 is pretty straightforward because the lot is not being subdivided, so we won't go into that. Under required finding number 4, required finding number 5 speaks to access to a roadway. It's a town road. It's 22 feet wide. It's the access would be adequate in design. So there's not much to be said about that. But the study, and Mr. Bannon gave us a great description tonight, that study and permitting and approval really is for the next stage of review. So we can leave that in abeyance. In regard to condition, requirement number 6, that the subdivision provides safe and adequate local circulation and adequate surface runoff, et cetera, I point out that this is partially met. With regard to runoff, the concept plan is shown, but its viability is in question due to a lack of certain on-site water table information. You're starting to hear a trend here, right? Circulation, again, I said the traffic study will need to be reviewed. No comment at this time, maybe at a preliminary. The building sites, the applicant must adjust how their design will comply with the new CRMC buffer, as I just mentioned. Required finding number 7, that the location of streets, building lots, utilities, drainage, et cetera, shall minimize flooding and soil erosion. I suggest that this requirement has not been met until such time as the drainage plan for this development is completed and approved by engineering. Now, that is a permitting element, and that's technical engineering. Mr. Doherty would say, and I will say it for him, that is not required at this stage. So we would have to leave this in abeyance also as a condition of, that we would carry forward. Now, when it comes down to required findings under the affordable housing law, the law that Mr. Santilli is employing here, the first one is that the proposed development is consistent with local needs as identified in the town's affordable housing plan. I acknowledge that it is numerically consistent with local needs, as it would increase the total LMI inventory by 5 units, and we know we are several hundred short. It meets the minimum standard of 25%. However, the staff notes that the addition of the 15 market rate units, which Mr. Brady has mentioned more than once, will dilute the net effect toward our 10% goal. Were it a proposal for just 10 units, say, with 5 units being low mod, then 50% would be, that would be a 50% improvement and would have a much greater positive impact. The second required finding is that the proposal is in compliance with standards and provisions of the Narragansett zoning ordinance or subdivision regulations, and/or where waived, local concerns do not outweigh the state and local need for local and moderate income housing. This is the required finding that the developers rely on. Because we cannot say we've met our 700 unit requirement, that we must accept the proposal. I don't agree with that. We know that it doesn't comply with several zoning and subdivision regulatory requirements. I will hit those in a moment. But the scale of this development has not been justified. Moving on to waivers, and let's talk. There's 7 waivers that were requested in Mr. Privé's letter in mid-January 2023, and there's one more that they didn't note that I put into the memo. The site coverage standard. In R80, the site coverage standard is 10%. They're asking for a coverage of 22.6. So they're requesting more than 100% relief. Staff has a major concern that any relief granted from this standard be the least necessary to achieve a viable, and I underscore the word viable, development. And I'm going to come back to this thought in a moment. The second one has to do with multifamily meeting all the standards of Section 17. So that's kind of a procedural comment. We'll move to C. The minimum lot area in an R80 zone for a multifamily development is 10 acres. They have 6.16. They're requesting relief from that. I did note that if this were an R10 or an R20 zone, they would meet the required standard. And staff is certain that the larger lot requirement in the R80 zone is intended to ensure development of a commensurate density for the surrounding areas. A gentleman representing the abutters mentioned something about self-created hardship. I hadn't thought of that. This is the subject of a previous subdivision. They have already reduced the size of Lot 30 by 50%. It was a 12-acre site, as we all know from discussion of the deed. Density requirements, 20 units on 6.16 acres, results in gross area of 13,416 square feet per unit net, once they take out the wetland that they admit to. It's 11,173. In my response to this, I've said density relief in comprehensive permit projects is not unexpected. Every single one we've ever had has had density relief. However, in this case, the proposed request would vastly exceed the allowed density, as we know. And it is clear that the combined application of development standards in both Section 17 and Section 4.5 which is the high water table zone, are intended to work in a complementary manner so that developers in areas such as this are sensitive to the impacts on natural resources of the town. This zoning regulation can be waived when a development of appropriate scale and access to utilities and very low potential for environmental impacts is presented. In this case, without sewers available and the high water table we've harped on, staff finds it hard to support that. Density regulations. This has to do with the parking area, 17.2.9, and I believe with our new regulations allowing and accepting enclosed parking in garages, I believe they can meet that, and I don't believe that's an issue of major concern. Same thing with 17.210, distance between buildings. That provision is really for big multifamily apartment or condominium complexes, usually with big buildings. With buildings that are the size of a standard duplex that we've got here, I don't see a real concern with allowing the minimum distance of 50 feet to be reduced to 25. So I have no objection there. In regard to utilities, Section 17 is very clear. Sewer service is required in areas with soil limitations. And the lot coverage density standard is a shall, not a may. So I think we have to take that seriously. I'm going to say it again. The plan is not as submitted has not provided enough background information about the natural qualities for my staff, for the engineering staff, for the Conservation Commission, and others to draw positive conclusions. More information would be helpful, could bring us much closer to agreement with the applicant, but in the absence of those, it's very difficult for us to support it. And in regard to public water, I believe the board's already heard what they need to hear on that. I think you do need to consider what Mr. Natalizia said and the gentleman who spoke about needing the town of North Kingstown's approval. There's one more waiver that has to do with dedication of land for public purposes. Every development shall dedicate land or fee in lieu for open space. And it doesn't usually get implemented with smaller developments, but with larger ones it does. The formula set forth in this section indicates 1.29 acres as the minimum requirement. The pre-plans indicate a proposal to make land conveyance of 0.73. It's about 3/4 of the way to meeting the standard. But keep in mind, if this development were made smaller, if the amount of impervious surface were reduced, all these issues that we've raised could easily fall into place. So you've seen my commentary. I have suggested some conditions for certain waivers. I think the board should be very concerned about 126% variance on site coverage.
Yep.
And same with density, et cetera. Moving to my addendum. It's only 3 pages, folks. First few things in my addendum, the supplemental issues for consideration. I believe Mr. Doherty has addressed a few of these, but I just want to get this on the record. As of today, when I wrote this, I had not received any information on corrections to the pro forma.
All right, we have
I know
that
we
now.
received it tonight.
Yep.
That's item 1. Item 2, soil and water table data. We have not received any on-site test data in the areas that we requested.
Right.
We had some, it was shown, but it wasn't in the areas necessary. Wetland edge, same thing, I already mentioned that. Verified edge has not been submitted to us as yet. The deed to the property. It was discussed early on by Mr. Marcella, and so I won't get into that, but the deed issue needs to be cleared up. And the last 2 points I think are very important. Substantial progress. Mr. Pimentel made some commentary that the town had made substantial progress. And he even made preemptive commentary tonight before I had a chance to make my opening commentary. So let me just say this. I gave you a chart. It's right at the back of this packet.
Yeah.
Let's go to that chart for just a moment.
You don't have it on the screen? Do you have it?
Sorry, I did not, you asked me to put that on, I apologize. Folks, for the folks in the audience, what this is a chart I've drafted in late 2007 or 8, and I've been updating since then. It tracks every single affordable housing development in town. And what we have done over the years is, what this board has done over the years is have approved 9 out of 11 applications. So we are not opposed to affordable housing in this town. Of the 9, 6 were built. In total, and every single one of those 9 applications exceeded the 25% minimum of affordable housing. In fact, when you average them down, the affordable housing component is 62.9%. The 2 that were denied were submitted at the 25% range. So let's take a quick run with the numbers. The 9 approved applications authorized 259 units, of which 163 are low mod income. The 163, and then the 163 were not all built. Some are still in process of going through final, but this board approved them. In the same time that my study has been undertaken, since 2005 actually, the town has issued permits for 672 new residential units. That equals about 40 units a year on average. When you compare that figure with the LMI figures, in other words, take the LMI 163, put that over 672, you get about 25%. So about 25% of all the houses built in this town since 2005 have been low mod income houses. And one of the things the public doesn't know, but this board knows, is that many of the subdivisions approved in this town, in fact, the vast majority of them, have been small subdivisions, 2 to 3 to 4 to 5 units, which are not required to have affordable component. So the fact that we've gotten 25% of all of our dwelling units in the last 17 years, I consider that to be very substantial progress. Now, moving on to proposed density. So what justifies 1 unit for every 11,000 square feet of land? This applicant's request is for nearly 700% density increase. His experts have yet to explain why 20 units makes sense. Why not 10? Why not 5? Why not 125? His land use expert asserts this is reasonable, but offers no substantive reason why it is. He notes that the town is 500 units short of the 10% goal. We can't hide those numbers. He cites the comprehensive plan stating that build-out will incorporate 1,000 year-round homes. While that is the stated policy of the plan, it does not address or accommodate the affordable housing density bonuses that we're talking about here tonight. So the 1,000 units is probably not a real number if virtually every other development we're going to have in this town is going to have a density bonus, that number's going up. So I ran some numbers real quick, and this is thumbnail numbers. You'll see them on page 3. The total land area of the town is about 8,770 acres. Vacant land, as of, these numbers are somewhat dated, vacant land as of 2017 comp plan was 4,437 acres. Let's assume, because I've already I've looked at the maps of the town, assume that 75% of that 4,400 acres is either wetland or somehow else constrained, so that we only can use 25% of that. Let's subtract, that brings us down to 1,110 acres. Let's subtract 15% for infrastructure and for land that's in other zones, like commercial. We don't have a whole lot of it, so that's not a big number of commercial units. That brings us down to about 41 million square feet. I've shifted from acres to square feet. Apply the proposed density here for tonight, 11,200 square feet per dwelling unit. We would wind up with 3,670 dwellings. If you apply the 25%, the bare minimum of potential dwellings, which is not what this board wants, they would want 50% affordables, maybe even more. But if you apply 25% to that number, it would result in 918 low mod income dwellings. We only need 500. It's nearly twice the amount that we need. So, and I know these are round numbers. I can't get this down to perfect, exact square footages, but these numbers are reasonable for our discussion here. Given that above estimate, it would be reasonable to suggest that the necessary average density for low mod dwellings at a 25% development plan like this one is, could be somewhere in the range of 22,400 square feet. That's 11,200 times 2. And I would suggest this average could also vary based on the zone. In the R80 zone, it might be a little higher, a little more land area. In the R10 zone, it might be a little less area. So in the end, I would suggest that this project, if we wanted to make this project fit and be appropriately sized for the area it's located in, the constraints it's got, and its zoning, it could easily be reduced by 50 or 60 or 65% and be defendable. You have to remember that if this project does get approved, if you folks do want to approve this tonight, I would suggest that one of the conditions that you put on it is the area of disturbance be limited to what is shown. Because I am certain, almost certain, because I'm not an engineer, that to build those 20 units, they're going to have to spread them out in order to get the drainage and the wastewater to work. And I think you should, because Mr. Doherty said it would happen, that you should anticipate that if they cannot meet all the regulatory requirements, that density should come down. And you should make that a condition of this approval, if you approve it, that density is not vested here. The maximum density would be 20 if everything worked out perfectly. I had one more thought. That's all I had.
So I'd like to give the board the opportunity to ask any further questions or commentary, and then I'll give Mr. Doherty a last summation, if you could. I don't want to go back and forth, but, you know, you want to react to anything and then give us some. But, gentlemen, do you have anything else? And then we'll get to a decision. Joe?
All right. Well, the comment was made that this proposal fits with the town comprehensive plan, and I don't agree with that. We had, what, 2.5 years of meetings with town people, 32 meetings? 32 meetings with different groups in town. We spent 2.5 years looking at the makeup of the town, and this particular area was discussed, I remember that. And the thinking and the concept at the time was the open space. And the comment of the proposer council here is that created opportunity for this type of development. It's certainly not the flavor that I remember at all those meetings, and certainly at the meeting where this was discussed. And the implication that we're not going to meet this 10% requirement by the state, what is it, 25? That isn't 25, is it 28? Yeah, but what year, I'm saying? What year, Mike? Is there a year? Yeah, is it 2025, 2030, when is it?
It's based on our own plan, and we projected in the 2005 comprehensive plan that we would almost be built out now. But in the most recent plan, I believe build-out is targeted to somewhere around the year 2030 or 2035, somewhere in that range.
Okay, and I don't know about anybody in this room who loves Rhode Island politics, but the idea of each community having this imposed on them, this 10% number, is like fantasy land, right? But in any case, it's imposed, and the threat is that they're going to somehow take some type of governmental dollars away from each town that doesn't comply. So that's the threat, that's the stick. And, you know, along the lines of development of these units, we could suddenly have a windfall because, remember the Christian Brothers development that came before us had 132 affordable units. How about that? In one shot. So there are other possibilities out there, and I think the number here is what, 0.04% or some number like that, that this would satisfy in terms of our need for affordable housing. So I find it very hard to get behind something like this in an area that's wet, that's open as it is, and in terms of what the community has been presenting in terms of people who live in that area. I understand the developer owns the property. I understand this is America. We all have rights, and I understand what they're requesting, but it's it's very tough to get behind. We need affordable housing. I said that earlier. We're struggling at the hospital to get places for our nurses and our technicians and everybody who would love to live down here. And there's no, how long can you live in the Holiday Inn? The hospital has to pay that for you. So those are my thoughts. This is, again, I've said many times, the 10 pounds of potatoes in a 5-pound sack. It's too much, and what is proposed and sitting in front of me, I can't support.
Thank you, Joe. Mark, Rupert?
Yeah, I have a few things. Again, we as a group and as a town representatives are passionate about expanding affordable housing. It's vital. The question here in relation to the comprehensive plan is, does 0.05% outweigh the impacts of the zoning area? And it comes back to our original conversations. We sat here at an open meeting here, and the only thing we discussed was the density. And it was reduced by 1 unit, and that unit was an affordable unit, which still dumbfounds me. You look at the area, it is zoned R80, specific. It's defined why. Wetlands, water tables, runoffs, not only on-site but off-site. The applicant states in their own study, if you look at dwellings to the west, you're talking 1.3 dwellings per acre. I'm presuming that probably has sewer, town sewer. On this side, it's 0.3 dwellings per unit. So from their own engineer, they're saying that the capacity in this area at a 6.1 acres is either 2 to 8 units. We're looking at 20 units. Again, makes no sense. At least it hasn't been shown to me to make sense. I know at this point in time, traffic is the next step, not at this step. But the traffic was given to us. And I have some real questions that I've expressed tonight on the questions of traffic in a rural setting as defined by the traffic engineers. I have a question with the lead assumption being that this is a small-scale residential project. It is not. Not even for here, but for most of this community, this would be a significant impact. It makes no sense to me. And again, that comes in the next level. As it stands now, I applaud the affordable units. You can hear the outcry in the fact that the loan unit that was reduced was affordable. It has nothing to do with that. Do have extreme issues on the questions of density, and if you look at density, it is the dominoes that tips everything else in this plan. There are questions, obviously, about that have been brought up in other areas, including the water easement and what goes there. But I think it all comes back down to the question of density. Thank you, Mr. Chair.
Mr. Friday, do you have any comments?
I think most of the key points I have already been made. My largest concern, and I wasn't here for the pre-meeting on density, but density is my primary concern. The resulting impact on OWTS and lot coverage, stormwater, in a site that in the comprehensive plan is defined as a environmentally constrained site. So I think that's a real concern. I think the impact on traffic, and as has been stated, that comes at a later stage. But I think the transportation analysis gave pretty short attention to pedestrian traffic, and I think that significant additional trips on that road with the pedestrian traffic, I think, is an important impact. And then the minimal impact on Narragansett's affordable units, I think, is important to note. So I pretty much in concurrence with most of the comments stated.
Thank you, thank you. So I'll just very briefly, sure. I understand the need for a density bonus. And these are things that I've discussed and we've discussed, but I've stated in the past and from the beginning of this project and other projects, but I understand the need for the density bonus in the state law. I understand the need for a developer to build extra units to offset the cost of affordables. I think Mr. DeLuca is absolutely correct. I think, and I've sat on, I think, on the board for all, but perhaps Camp Jory, or maybe even that one, and Dr. O'Neill has. We have been, this board and this town has been very receptive to developers and projects that brought in more than the bare minimum, that actually made a commitment to the affordable housing, and we have to continue to push for that. The ones that we have not supported are the ones that, in my view, are using the comprehensive permit provision of the law to ask for, and again, it's my word, an excessive amount of units, and are bringing, maybe reluctantly, the bare minimum to town. Because I think if they were committed to that affordable housing, they would bring more than the bare minimum of 25%. We had the pre-application meeting. We discussed our views that there was too much, density was too high, and the ratio was not correct. There were not enough affordables. And I know Mr. Doherty the other day, last meeting, made a comment back about that they listened to us about the age restricted. You did, but not about the density, because we definitely said it was too much and that there weren't enough affordables. I understand, again, the reason and the need to provide the density bonus. I understand this is going to take steps into the future, and we'll see what happens to it. But, and And I'll say again, I've said this before, no disrespect to the legislators, or maybe it is, I don't know, or the planners, but it doesn't seem correct for us to make all these decisions on vesting units without having all the engineering and environmental information. And I understand that a developer maybe shouldn't have to expend all the money for that, but it's very difficult for us to do that without the exact information. I think everybody talked about wetland edges and water tables and runoff and drainage and all that, which is the next stage. Even traffic is the next stage. So, but this is what we have to deal with. And I think bottom line is there's enough concern about the issues in front of us. Water table, no sewer, all those issues that doesn't allow me to then justify the density bonus. It's just too many units for the red flags that have been raised legitimately by staff, by experts, by neighbors. There's too much, in my view, of concern to then accept 20 units. And so I'm not going to support it either. Mr. Doherty, do you have a final word?
Can I just,
No, yeah.
can I ask one question of Eric, maybe? So
Who do you want to ask a question of?
Maybe the engineer.
Oh, go ahead.
Yeah. So, again, for the record, this was dropped on us tonight. One of the issues which I've been harping on is the water easement. And I'm reading the order, and it's my understanding that there's currently one pipe in servicing one house. Is that correct to your knowledge?
To the best of our knowledge, yes. We did not obviously physically dig it up, but to the best of our knowledge, there is one pipe, a 2-inch existing pipe in there.
And the applicant or their agent came in or sent an email on Friday to the town. The town responded today regarding the need for a 6-inch pipe
Correct.
into that services.
Correct. As part of the fire hydrant, that would be a minimum of a 6-inch to service a fire hydrant, yes.
So can you just give me your opinion? The scope of the easement says the premises herein, which is the global premises, herein described are conveyed together with an easement 25 feet in width to lay and maintain a water pipe as it is more fully described in the instrument in deed book 101, page 549. Deed book 101, 549 delineates the scope of the 25-foot easement. It doesn't say 2 water pipes. It says a singular water pipe. How would your plan impact the limited scope of the recorded easement, is my question.
So at this time, we would, it was envisioned that we'd be replacing the 2-inch with a 6-inch line. So there would be a single line coming in, replace the existing 2-inch with the 6-inch.
So,
And the property to the south would have a service that would continue to stub off it as it has been doing and will continue to do.
with one larger, you wouldn't have 2 in there?
I'm sorry?
You wouldn't have 2 in
We're
there?
not planning on having 2.
Okay.
Thank you, Mr. Good. Anything else?
Yeah, no, that was, I'm sorry, Doc, did you have a question? Okay.
Joe, did you have something?
Yeah, a couple of people in their letters wondered, why are we making a decision tonight, right? Stuff just came in today. Well, we're, unfortunately, I shouldn't say it that way. Some of you people here may have a project, and you walk in to see Mike, the clock starts running. That's good and bad, right? It's good because you're paying attorneys and engineers and whatever, and you know that within a period of time, it's going to move. You know, you have to have a bunch of material in to start the clock running. But so there's a 90 days, isn't it 90 days?
Yep.
90-day time, the clock begins, and it's now for us. So I know a couple of people had that in their letters wondering, why are we, what's the hurry here? And as you heard, and I resent the fact that we get stuff now. What's that? Why? You know, I just, I really think that that should negate this whole process. You walk in the last minute and drop something on the desk over here, and then we're going to vote for this or against it? There's something wrong about that. That's my statement.
Thank you, Doctor. Okay, Mr. Parry, did you have a last word? I don't know what else needs to be said, but go ahead.
Although this is exceedingly difficult for me to do as a lawyer, I don't have anything much to say.
Oh, let the record show. That's a first.
I would just echo the common thread of concerns that this development is too dense, too big for this parcel. It's R80, and the environmental concerns, as our experts testified, have not been adequately addressed at this stage. Thank you.
Thank you, sir. Last shot, Mr. Doherty, if you could do it, and then we're going to go to a decision.
Thank you, Mr. Chairman, and members of the board. I appreciate your patience and your opportunity and all the time that you've put into reviewing this project and all of the effort in going through these proceedings. I would just like to say we knew this was going to be tough going into it. Mr. DeLuca has made it clear from day one that this was a project that he was opposing, and I think that he has been zealously advocating against this project from its inception. We submitted documents back in November to get the ball rolling on this thing, the first week in November, and back and forth we received a number of certificates of incompleteness or statements of incompleteness. And at one point in January, we just decided that we felt that we had supplied everything in accordance with state law. Other issues came up in the meantime that were brought to our attention as well. That's hence the receipt of some other documents to put in the record. And they're really documents of deeds and easements and things of that nature. And I believe these will all be played out and rectified. But one of the things that I do want to point out, again, Mr. Chairman, you asked Mr. DeLuca to confine his comments to the supplemental amended report. And we went through the whole thing again.
Right.
The whole thing, everything.
That's fine.
Right? I didn't interrupt you, Michael.
No.
I didn't interrupt you, Michael.
No, I'll tell you, Mike, I'll do it. I'll do it. He's fine doing that. We want him to do that.
Okay.
I have no problem with that.
All right, well.
You don't have to, chastise Mr. DeLuca.
No, I was making my point that there is
I would have stopped him if it wasn't appropriate.
Yeah, well, this is an advocacy.
Mike knows that.
Yeah.
More than once.
Sure.
So go ahead.
So it's clear, there is an advocacy against the project. It's, there's a lot of people in the audience that are saying that their properties will be negatively impacted by runoff, by the wetlands will be destroyed, the sanitation and E. coli and fecal matter will be going in there. Well, we have to prove that that will not happen. And we have to prove, if this application were to be deemed approved by this board for master plan approval, we'd have to show that we would meet each and every single criteria, both in the town and also by the state regulatory agencies. And if you look at the wetlands, you did hear testimony from our person who was out there, the wetlands specialist who tested the soils and marked the, he marked the wetlands edge. We're awaiting that to be deemed re-upped by DEM right now. The wetlands haven't changed. If you looked at the graphic that was put up on the thing by Mr. DeLuca, this was not showing any wetlands in any impacting proximity to the proposed building and the road, or the private road. So we understand that we have to meet everything. And we understand that if we can't have this density on this project. And state law allows for an application to be submitted for this with the 25%. The legislature is taking some very, very drastic measures that are under consideration right now with respect to affordable housing. I mean, there are bills pending before the legislature here now to take everything away from a local city or town that hasn't met their 10% and put it in a total body outside of the town. So no zoning, no planning, no nothing, no town councils. It goes to a state body, and you'll have no say whatsoever.
We know.
So that underscores the need for meeting that 10%. And I understand that this will do 0.04 or 0.05 increase in that. But I disagree that there have been 25% affordable projects approved in the interim, because somewhere along the lines, 90 affordable units have been taken out of the equation, as testified to by Mr. Pimentel. But this will have a measurable impact on 5 families in the town of Narragansett that will have the opportunity to reside here. People's children would have the opportunity, staff, town hall, and the schools, people that wouldn't ordinarily be able to afford a house in Narragansett. So I think it will have a significant impact for those 5 families. I believe that we are complete insofar as the requirements of state law for submission of the application. That's why when we got our January 23rd submission, we pushed back, and I think we were right to do so. And I respectfully disagree that the application isn't complete. I respectfully disagree for the reasons stated. Well, I'm respectfully disagreeing and I have to make a record here.
I know.
Because obviously, when we get denied, which it doesn't take a master tea reader to understand where the vote is going based on the comments, and I take those to heart. But we have to make a record for an appeal, and I do understand that these are big issues that affect the neighbors, but we have to show that there won't be that negative impact on the neighbors. And if there is, this project won't go forward. A preliminary won't go forward at final. And with that being said, I do appreciate the time spent on this, and I would also request that all the town public records pertaining to this file that have been referred to or used or reviewed, and testimony and the topics of discussion be part of the record going forward.
Yeah, absolutely. Thank you, Mr. Doherty. Thank you to all your team. Mike, I'm not going back and forth, guys.
No.
I'm not.
Just to correct Mr. Doherty.
Okay.
Before he was hired,
Not going back and forth.
before he was hired, I had a conversation with his client. And we did talk about affordable housing on this site. We did talk about density relief. And I did say, in the right realm, in the right scale, I could be supportive of it. I want that on the record.
Okay, thank you. Yeah, go ahead. Yep, no, go ahead. No, you're the eldest guy here. Go ahead.
My thought is
Go ahead.
leading here.
Go ahead.
Steve? When, obviously, you know the flavor of the board here is to deny. So this then goes to a state board. This doesn't go into a court system. It goes to a state board, right?
Well, it's up to Mr. Doherty.
Well, no,
Well,
so.
that's right.
Yeah, so
Oh.
yesterday, I'll keep this real short. Yesterday, the House passed one of the 14 pending legislations that actually got rid of SHAB. However, so it may potentially go to SHAB. Okay. It may go to Superior Court.
That's the board we're talking about.
Yeah,
Shad.
the State Housing Appeals
Most of
Board.
these people don't know.
But that's just only the House passed that. The Senate, it's my understanding, and this has nothing to do, it's my understanding that the Senate isn't as gung-ho for all these bills as the House is, and then who knows what happens on June 30th when they just trade everything. But as of right now, and it would, as of right now, it would go to the State Housing
If-
Board of
Yeah,
Appeals.
but
Should,
that's his
whatever your
choice.
decision is,
Yeah,
you know,
that's-
again, because
that's
we
the
have a
attorney.
butter, so it may be
That's the
appealed.
attorney's
No
choice.
matter.
And it could possibly go direct to Superior Court if they pass one form of legislation. It could go to a state board outside, connected with the housing
Yeah,
secretary.
let me put it this way. Just make your decision based upon the
Right.
evidence, and
Right.
then we'll
I-
figure it
Well,
out.
I
And,
just-
and we can't presuppose what the applicant's going to do following this decision, right? Is it appropriate, Mr. Marcello, to close the public hearing so that the board can deliberate? Do I have a motion?
So moved. Close the hearing.
So close the public hearing, motion by Dr. O'Neill, seconded by Mr. Brady. All those in favor? Aye. So just the board will talk now. I just want to hear what, I want to hear a motion. I think, and I'll let Mr. Marcello, Mr. DeLuca add to this, I think the standards listed in Mr. DeLuca's staff summary have to be one motion. You can incorporate what's said, you can revise, you can edit. If you're incorporating, you don't need to delineate everything on the record. You can just do that as a matter of incorporating what's in there. But those standards have to be, I think, one motion. And then the second motion is the waivers. And so you would make a positive or negative recommendation on the waivers one by one. Again, delineated in Mr. DeLuca's initial memo. But the first motion, I think, guys, before I say this wrong, they're talking. Before I say this incorrectly, Mike's not listening to me. Before I say this the first motion has to be are all the standards met, and if not, which ones are not?
Correct.
Okay.
You know, it's your legal obligation, you know, to take the testimony you heard and all the experts and match that up with the legal standards that are your required findings. You can accept Mr. DeLuca's report, you can change it, you can
Revise it.
revise it, you can add additional testimony.
But if all the standards were met, then that would be a motion for approval that they met all the standards. And then the waivers would be recommended one by one. If they chose to deny, then they would have to identify which standards were not met.
Correct, and the reasons for that.
And the reason, which are delineated to some degree, if not a total degree in the memo.
Correct.
Okay.
And there's no reason for a preliminary.
No, it's not, that's not. You guys got that? You good with that, Mr. Brady? Mr. Sure. I'm sorry, but we do need to have a 2-minute break, and let's just do it 2 minutes.
I just want to explain to people, I'm recovering from surgery, so this has been a very difficult haul for me, and I just need to walk.
He's a trooper, and he needs just a 2-minute break.
Yep. Yeah. Give him hell, Mark.
You ready, Dan? Thank you. We're going to call the meeting back to order. The public hearing has been closed. The board is deliberating. It's time to make a recommendation. As everyone said, this is master plan. At this stage, if it's approved, then they go on to preliminary. If it's denied, then the applicant decides whether they're going to proceed or appeal it. And then, as you heard, that there's some place to appeal it. We're just not really sure exactly where it would be. But this will be the end of the master plan phase of this project. So who would like to make a motion relative to the standards met or not met?
Post-surgical patient.
Thank you. All right. You guys are making me work overtime today. All right, I'd like to make a motion based on the, what are we calling this? Master Plan 500, Old Boston Neck Road, comprehensive permit, 20 total units, 5 affordable, assessors plat, NB, Lot 30A. I would move denial of the petition based on the following conditions. Condition 1, page 7, finding of fact.
Excuse me, referencing page 7 of
Yeah.
Mr. DeLuca's
Mr.
memo,
DeLuca's
so we
memo.
know what's being incorporated. Thank you. Go ahead.
While there is a affordable component of 5 units, the offset of the 15 minimizes the benefit to the community. What not mitigated is the impacts to the density. Even the applicant's own research shows development in the area to the west being
I just want to make clear, the first standard's on the comp plan.
Yeah.
So,
being 1.3 units per acre, which would be 8 dwellings, and that area is serviced by sewer. This is not. Adjacent to this is 0.3 units per acre, which would be 2 units. The primary issue here is the density and the effects of that density on the development. Number 3, no significant negative environmental impacts from the proposed development. Find that this is incomplete. The applicant has the duty to provide sufficient evidence of the site's capacity to support the proposed development. All right, this is a large development, large density development in an R80 zone, which has been identified with water table issues and wetlands questions. 5, all proposed land developments and all subdivision lots shall have adequate and permanent physical access to town, state, except and approved streets, lot frontage and/or town except or approved streets without physical access and lot frontage. Okay. The staff acknowledges the site has direct access to Boston Neck Road. Whether the proposed access is adequate in location and orientation remains to be determined. As I've stated here, I have issues with the traffic study as presented, and I was very definitive about those questions. 6, each subdivision shall provide for safe and adequate local circulation for pedestrian vehicles through traffic, for adequate surface water runoff, for substantial building sites, and for preservation of natural, historic, and cultural features that contribute to the heritage and attractiveness of the community. The staff finds this element to be partially met. This item in need of further analysis. Our runoff concept plan is shown, but its viability is in question due to the lack of certain on-site water information. Circulation. Traffic study will be needed to review and comment, and I've already made my comments on the traffic study. Building sites, applicant must address how the design will comply with the new CRMC buffer and jurisdiction area required for 7 units, for 7 of the units noted above. Right. 7, the design and location of the street, building lots, utilities, drainage improvements, and other improvements in each subdivision shall minimize flooding and soil erosion. The staff finds this requirement has not been met until such time as the drainage plan for the development is complete and approved by engineering staff. Additionally, staff is uncertain of the applicant's legal right to access water service through the easement to the rear. No documentation of that easement is its owner, is allowed user, and its possible expansion.
Okay, can we stop there?
Yeah.
Is that the first motion before we get to the affordable housing components?
Well, Mr. Brady couched this all with a motion to deny. So I believe his approach here is incorporating the findings. Maybe he's going to get into discussion of the waivers.
No, we're going to do that
We're
as
gonna
a
do that
second
separate.
motion.
Well, so if we're doing a motion to deny, you don't really need, you don't need to vote on the waivers. However, there are, to supplement what you're saying, there are other additional required findings under 40, which would be subsection B.
B, right.
And if some of the reasons for your denial are included in subsection B, whether it's, some may not be, or
Okay.
some may not be applicable, then you should state that now.
Okay, go ahead, Mark.
Okay. Subsection B, the required findings under section 45-53 of the general laws of Rhode Island. The proposed development is consistent with local needs as identified in the Narragansett Affordable Housing Plan or has addressed issues where there may be inconsistencies. Staff notes the addition of 15 market units will dilute the net effect of our 10% goal. Where it was proposed for 10 units, with 5 being LMI, 50%, or total 12 with 6, the staff would find this to be more significant in addressing our local needs. 2, the proposed development is in compliance with the standards and provisions of the Narragansett zoning ordinance and subdivision regulations, or where waived local concerns do not outweigh the state or local need for low and moderate income housing. This proposal does not comply with several zoning and subdivision regulations. This memorandum addresses this applicant's list of request waivers in section C, waivers below. All right. All low and moderate income housing units are integrated throughout the development, are similar in scale and style of the market rate units, and will be built and occupied prior to or simultaneous with market rate. This proposal does not identify which units are proposed to be designated for sale at 120% AMI to income qualifying buyers. Staff cannot assess the proposal's compliance with the standard and the justification.
Go ahead, Steve.
All right, so in your reasons for denial, you're accepting, you say
Right.
staff, but you're accepting the staff recommendations
yeah,
as
I'm
the
sorry.
board's decision for.
It's the board's decision. I thought that was assumed.
Right, but you're incorporating the
Incorporating
staff's
staff findings.
points.
Correct, even though you're saying staff, you're incorporating that as your
Exactly.
reason for this.
Okay?
The others, I think, have been addressed.
Yeah, I think
in
the others
other
have.
things.
I think the others
And
have.
we don't have to work on the waivers.
No.
Okay,
Assuming the motion passes.
Right.
assuming the motion passes. So can I just have a quick sum of the standards 1 through 7 that were not met in your motion?
1, 3,
One.
5, 6, and 7.
1, 3, 5, 6, and 7, and you're incorporating staff's comments.
Staff comments, as well as.
Justification for those.
Yeah, as well as findings from the last 2 meetings.
Okay.
Are you also incorporating B1, 2, and 3?
Yes.
Yeah.
B1, 2, 3. Okay.
You need a second for the motion?
We need a second?
We need a second.
Second.
Motion by Mr. Brady, second by Dr. O'Neill. All those in favor?
Aye.
Good luck. Thank you. And can I have a motion to adjourn?
Oh,
What?
Wait,
What?
what happened?
There was a motion to deny, which passed 4-0, so.
And it does not meet the finding. Do we, so those are the reasons for the.
For the denial. Yep, 1, 3.
Okay.
5, 6,
I
7,
just
and
wanted to make sure everybody understood that
ABC,
those are
with the
reasons.
rationale that was incorporated from your memo.
Sorry, didn't mean to keep everybody.
Motion to deny, I mean to
Yeah.
adjourn?
Seconded, non-debatable.
Move to adjourn.
All those in
And God bless
favor?
America.
Thanks all for coming out.